My lord, this criminal appeal may be kindly taken up tomorrow, my.
Okay.
May I please, Your Lordship?
Yeah.
My lord, I beg to mention item number 1. It is briefs with Purkastra sir, my senior. So he could not come today due to that is his physical illness. So matter may be listed on 28, my lord.
28.
Or
But it has been not taken up for long. I think not moved till date. I think it was filed earlier. On the
Lordship, October 27.
27.
नहीं, देरी हो गया ना?
Item 1
Item 1, my lord.
on the prayer
Ah.
made by Mr. Judeka, Land Council for the list this matter
On 27, my lord.
on 27 October.
September. 26, na? My lord. My learned sister informed me that 27 is holiday and 26 is last working day. So 26 maybe.
26.
Oblige.
My lord, item number 30, 31, 32, Lordship. This is connected matter, Lordship.
Item
Item number 30, Lordship.
13.
30, 31, 32, Lordship. 30.
30.
Lordship, I have taken consent from the opposite side also. This may be listed after
This
vacation.
is in order. We'll see. We'll see what for it has been listed. Okay. In order, adjournment not required automatically. Okay. We'll see. What? Okay. Just wait for some time.
By taking mention item number 39 and both are connected. Taken consent to the
Criminal petition for what?
proceeding before the CGM sector, the next CGM sector.
On merit. Okay. So you have taken consent. Okay. Mr. Arkoyo, Lana counsel for the petitioner, with the consent of the Lana counsel appearing on behalf of the other side, prays for listing this matter after
2 weeks.
after 2 weeks. The prayer is allowed. List this matter after 2 weeks. The interim order passed earlier shall continue till the next date of listing. Okay.
May, my lord. My lord, I beg to mention item number 2.
Item 2.
Yes, on behalf of Keloya for the petitioner. With the consent from the other side, I have taken consent, my lord.
You are Mr.
P. Harming.
P?
P. Harming. P.
Your name is there,
No, my lord, it's not reflected.
appearing
On behalf
of Mr.
Keloya.
K. Lolen. Lana counsel for Lolen is for the
Keloya.
lawyer is for
Petitioner, my lord.
lawyer. Okay, K. Lawyer. Lana counsel for the petitioner.
Matter may kindly list after 3 weeks, my lord.
With the consent of the Lana counsel of the other side, prays for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks.
My lord, there is an interim. Interim may continue.
The interim order passed earlier shall continue till the next date of this.
Deeply over.
My lord, as I mentioned, one unlisted matter. Kindly this matter will be taken up after vacation.
Item
No, one unlisted matter.
tomorrow.
No, after puja after vacation.
Unlisted.
Yeah.
It will automatically be listed.
So actually, this matter is pending. So this matter is actually
Okay, it's pending matter.
It's a criminal petition
Okay, after
after vacation.
vacation. criminal petition is pending before this court. You want that matter to be listed after vacation?
After vacation.
Okay.
Hello. Item number 3.
Yes.
My lord, decision appeal filed under section 173 for award and judgment against it. Order dated 8/4/2025. My lord, this MSCT case was dismissed only one of the proof of rust and negligence, even though there was admitted fact about of the accident by the driver also. So this is my request to this honorable court. Maybe please issue notice. This is an appeal filed under section 170. So it is dismissed by the learned MSCT Tribunal Teju, District Lohit. So only for the want of proof of rust and negligent driving by the driver. Also, it is admitted by the driver.
What vehicle was this?
There is a vehicle, a government vehicle.
Government vehicle.
Government vehicle, my lord.
What vehicle?
This is Jeep also, my lord. This is one Jeep.
Car. Maruti. Maruti car.
No, my lord, Gypsy. Gypsy.
Where?
It is
In the judgment, it is mentioned Maruti car.
Yes, my lord, but it is in the police report. It's a Gypsy, Maruti Gypsy. It's Maruti
Gypsy.
Yes, my lord.
But it is mentioned car. Car cannot. Normally, government doesn't purchase car.
Yes, in the judgment it may be mentioned, but in the police report, this is a Maruti Gypsy. Page number 14.
Okay.
Page number 14. It is a 54 form, my lord. See the para number 6, registration number of vehicle and type of vehicle.
Okay. This belongs to government.
Yes, my lord.
Whether the deceased was a government employee?
No, my lord. Actually, at the time of accident, this was in a situation of flood. So, to rescue the people affected in flood, as per the instruction from the circle officer, the deceased person was
No, what he was doing?
he was going with the vehicle to rescue the people.
No, what was his profession?
His profession was a general people, nothing any let's say just business.
Is there any order whereby you have been engaged?
Yes, ma'am. No, yes, my lord. This is a there is an circle officer direction. It is admitted in the NDRWS also. So the person was bring to rescue the persons affected in flood. So during the course of the rescuing, the vehicle got down in a deep water.
No, how do have you proved before the trial, before the tribunal,
It is admitted by
that he
the.
was engaged by the administration?
There is no any documents, but in the in the written statement submitted by the respondent, they also admitted.
Have you annexed?
Yes, my lord. See the page number 29, 23. 29 to 31. Page number 30, para number 21.
Page 30.
Yes, my lord. Para number 21. That the contents of para 21 of the petition are fact that an evacuation team was ordered by the circle officer, Sunpara, to evacuate the VKB students who were at a risk due to overflowing of the water in the area. While I was directed to drive the vehicle by the then circle officer and was driving the vehicle towards VKB school. However, due to sudden rise water level on the road, I could not see the road, and due to the hovering and the evening hour, all the rescue team, including myself, were down into the water. Somehow, some of us were managed to swim out from the water, but the deceased person was struck up in the water or in the vehicle. Do not know and how he died. At the time of accident, I was having driving license to drive, and on the solely direction of the circle officer in emergency, I drove the vehicle.
Okay, you file application under 160.
166.
Okay. So you could not prove. There was no evidence
There is no
to
evidence
prove
as
that
per
there is
the
a negligence.
yes,
There
yes,
was a negligence on the
Yes.
part of the driver.
yes. Due to only
Under the circumstances, whether the application lies under 166 or 163.
my lord, in the 166, even though it is required to prove the 279 and
In 166,
Yes,
you
ma'am.
have to prove,
yes,
but in 163A, kindly see,
it is not required to prove.
not required. Why don't you file?
So, my lord, even though it is, but there is an also a annexer I have enclosed here with my lord. See the page number 18.
Because it was in the plot and taken by the
Yes, my lord.
water.
Yes, my lord. In the
Okay,
page,
no fault of anybody.
there is an JMFC order, my lord, annexer C, page number 18. There is also mentioned that the rash and negligence driving was there.
How rash and negligence? You yourself says, and his statement itself says, there was no rash and negligence because of rise of water.
My lord, I want to read out the JMFC order. There is also some contents.
See,
prove.
the driver himself is
Yes,
statement in affidavit.
So, my lord, there is an-
evidence.
yes, the proof of the 279 is not fundamental to prove that there's a rash and negligence. There is
So
a
that is why I'm
sun one
saying
on only.
163A, you don't have to prove also.
Yes, my lord. So if there is a preponderance and a probability of the accident, we have to just prove it. It is beyond our capacity to prove the.
What is your instruction? What is your instruction?
We have not yet received the instruction, Lord.
Can we convert it to 163A and pass order, or what do you say?
Let me, I have to take instruction from the claimant.
You also obtain instruction, you also, both of you obtain instruction, and then if you agree with, then this matter can be disposed of under 163A.
No, it's not.
And then the basic, all those compensation, what he was doing, he was only public.
It's just public.
What was his earning you, as per your application?
National income that may be taken.
National,
Yes,
okay. Obtain instruction,
yes, my lord. I
Okay.
have to take.
you also?
Okay.
Because earlier, probably, you took time to obtain instruction before placing it before the
For arbitration.
settlement from mediation.
For arbitration?
For mediation. After mediation.
No order was passed. Probably mediation, if they don't understand, it will be difficult.
Yes.
And it will be better if it can be just disposed of under that. Because this, in any case, but he died while performing duty for the government, being engaged by the government.
So I'll take instruction.
Okay. Mr. B.R. Das, Learned Counsel for the appellant. And Ms. P. Sangeeta, Learned Government Advocate are present. For the respondents are present. So both the Learned Counsels. So Ms. Sangeeta was to obtain instruction, and some is that she yet to receive instruction. Mr. Das, also Learned Counsel for Appellant, also want to pray for some time to obtain necessary instruction regarding the conversion of this. No, we will not say that. Okay.
Yes.
leave that. Let's wait for Kamalu's this matter after
vacation, my lord.
after vacation.
But appeal may be admitted. And LCR may be called.
Not yet admitted. It was
Not
admitted. Not yet admitted. We'll see. On that they will pass because if it is to be converted under 163,
Yes, my lord.
we'll have to admit under that. Okay,
Yes.
after
Right.
vacation.
Item number 4.
So, my lord, this is an appeal filed against, under section 173 of MBA Act, against the order dated 28/5/2025. Judgment is passed against the MSCT case number 10/23 by the Honorable MSCT Tribunal, Bombdila, District West Tamil. My lord, this case is also dismissed for want of proof of rash and negligent driving. Although, my lord, the premium for the passengers of the vehicle was taken by the insurance company. So as per section 147 clause 5 of MBA Act, it is clearly mentioned that notwithstanding anything contained in any other law, if the premium is taken by the insurance company, it is the liability of insurance company to pay the compensation to the victims. There is also dismissed the MSCT case only on the relying on the documents of the MBI report. My lord, in MBI report, there is mentioned, I have annexed that MBI report in page number 29, my lord. Only relying on the documents, the Honorable MSCT Tribunal has dismissed the MSCT case. There is mentioned, my lord, how the accident is taken place. I have examined the accident vehicle, number such and such.
Where are you?
My lord, page number 31. In typical letter, my lord. Findings,
31.
31.
What is this?
There is a findings only on relying on these documents. This court once dismissed the MSCT case. The finding was that, my lord, I have examined the accidental vehicle number such and such at the spot of accident and also inspected the place of occurrence, the road at the point of sharp up and left twinning. At that twinning point, the vehicle was suddenly went out of control and went out of the road and fell down 50 meters and damaged. So my presumption, there is not accurate findings was given. There is only presumption. So my presumption, the accident took place due to sudden mechanical failure of steering system. So my lord, as the premium was also taken, I have requested the court that the premium is also taken for the person in the vehicle, that this is the liability of the insurance company to pay the compensation. So only on the documents,
Premium taken means
premium matlab, that means, my lord, this is an
insurance.
insurance premium. The premium for the persons in the vehicle, occupant premium. I have also
Is it
annexed that,
separate? If the vehicle was insured.
yes, separate premium was taken by the insurance company for the occupants of the vehicle.
Okay.
Yeah, so as per section 147, if the premium is taken by the insurance company, it is the liability of the insurance company to pay the compensation to the victim party. So as the
Where is the insurance?
policy, my lord, I have annexed that policy as an annexer D, page number 32. Page number
Where,
30.
where the
My
premium
lord,
taken-
see liability
taken is
section.
shown?
See liability section, my lord.
Which section?
Liability section, page number 3. There is a tables of liability. Right side, own damage and rest size is liability. Sir, my lord, there is a taken liability, third party liability premium taken 580. Thereafter, premium for 100 is taken
580.
PA personnel cover, owner and driver. Then after my lord, see legal liability operation maintainable for 1%. There was 3%, my lord. And then after the premium taken for legal liability to non-fare paying passengers, 2%. There was 3%, one there was an operator, and 2% was there was extra for labor such as. So 3% premium was taken. So my deceased person was the one of the occupant of the vehicle. Whatever he was conductor, labor, whatever, he was supposed to be taken as a passenger. Even though premium was taken for non-fare paying passenger.
And what the tribunal says?
Tribunal says, tribunal only on relying on the documents of MBI report. No, so 279 is not proved. So as per case was filed under section 166, we are not liable. There is an several judgments of the Honorable High Court that the proof of 279 is not sine qua non. Just preponderance and probability of the accident, we have to only prove. So, my lord, the case is meritorious.
Where is the impugn order? Impugn judgment?
Yes, my lord.
The operative portion.
Page number
Where-
13 to 24, my lord. (13 to 24), and the
Where
decision
is the
taking
operative portion? Where?
page number 18, para number 13, from para number 13. No, no. Para number 17, my lord. Para number 17, page number 22. Reverting back to the case in hand,
Page?
page 22, my lord. Para number 17. Reverting back to the case in hand, it can be clearly seen from the final report and MBI report executed by the claimant herself as exhibit number such and such, respectively, that the accident occurred only because steering failure of the offending vehicle, as the claimant miserably failed to establish negligence of the driver. I find application under section 177 is not maintainable. As this application itself is not found to be maintainable, I am not to discuss other issues. Accordingly, this application stays dismissed as non-maintainable. So, my lord, the court only on relying the exhibit number 5 and 7. That is the final report. Final report is given only on the relying on the MBI report. As the
Yes. Oh, whether it was admitted, already admitted?
No, my lord, I am appearing on behalf of the respondent number 1, Bajaj Alliance Insurance Company Limited, but the copy of memo of appeal just short while ago I have received. I will have to go through and I will have to take instruction, my lord.
Will admit then? Okay. Mr.
Better maybe admit.
Dear, sir, counsel for the appellant. This is an appeal filed under section 173 of the Motor Vehicle Act 1988. Why you are saying that for enhancement
My lord, as we are in the claim petition, we just claim 10 lakhs.
against the,
Yes.
against the judgment?
In
Is
the
it
claim
28?
petition, yes, my lord, in the claim petition, we just claim 10 lakhs. So
Hmm?
in our claim petition, in MACT case, we just claim 10 lakhs. So I have
Question does not
The-
matter, my lord. And
Your, see,
where there
petition
is
was
no-
dismissed.
No award.
Where is the question of enhancement?
Yes, my lord. Enhancement does not arise here.
28/5/2025, passed by the member motor accident claim tribunal. Where? Which tribunal? Where
my
have you
lord,
mentioned?
MACT Tribunal,
Where,
Bombay.
where have you mentioned? Where is? It's normally it is expected to be in the course title itself. Where is the name of the court or tribunal?
In our prayer section, my lord.
Bomdila. Order date is passed by the member MSC Motor Accident Claim Tribunal Bomdila in MSC case number 10/2023. Start. The appeal is admitted. Call for the relevant record. Call for the trial for the court. Issue notice. Since Mr. Udeka, Land Council, would appeared and accepted notice on behalf of the insurance.
Insurance company, Bajaj Allianz Insurance Company Limited.
Okay, respondent number 1, insurance company. No formal notice need be issued. You have not received a copy of, have you received a copy?
Today only, just
Okay.
short while ago, I
Okay.
have received a copy.
No formal notice need be issued to the said respondent, huh? Stop. The villain shall take steps upon the respondent number 2 and 3 by
Ma-
a registered post with AD as well as by usual process within a week from today. List this matter after 4 weeks.
Yes.
Okay,
My lord, yes, and LCR may be called for.
call for.
Oh,
Yes,
Item number 5.
My lord, this is an appeal filed under section 173 of MB Act against the order dated, my lord, 26/5/2025, passed by the learned MACT Tribunal, Tezu District, Lohit. For the grounds that, my lord, this case was also dismissed for want of proof of 279. So, my lord, even though there was a premium was taken for the driver of the vehicle, my lord,
okay.
I have
But dismiss on the ground,
proof of rash and negligent driving. 279, my lord,
proof of rash and negligent.
driving by the driver of the vehicle.
How it is?
My lord, actually,
Lack of proof or what?
yes, lack
Okay.
of proof of, yes.
So, will you admit it?
my lord, letter may be admitted.
Okay,
So hearing is required, my lord.
similar order.
LCR may be.
Mr. BR Das, Planning Council, the applicant. This is an appeal file under section 172 of the Motor Vehicle Act 1988.
Here I am
Against
appearing
the-
on behalf of Insurance
Judgment.
Company, United India Insurance Company Limited.
Against the judgment
Respondent number 1.
and award dated when it was passed.
My lord, it was passed on 26/5/2025.
Where do we find that?
My lord, in my synopsis, I have also mentioned, and in my
Not in a petition.
petition, I have mentioned, my lord.
See, it is expected that this information, case number, judgment dated while challenging in the first, you should have mentioned. It is expected that that is to be mentioned in the post title itself.
Yes, my lord.
It is not there. Whether have you made a prayer?
Yes, my
If
lord.
it is not in a prayer,
Yes, I have made prayer, my lord. In prayer section, I have also mentioned. And after, before para number 1, I have mentioned.
where?
In prayer section, I have mentioned, my lord, if you notice upon the respondent as to why the imprisonment judgment order dated such and such passed by the motor
Judgment
claim
never dated 26/5/2025, passed by the member motor accident claim tribunal KG in MSC case number 08/2016. Staff, the appeal is admitted for hearing. Call for the trial for the court. Issue notice since Mr. Dekar, Learned Counsel appeared and accepted not on behalf of the respondent number 1, United India Insurance Company. No formal notice need be issued to the said respondent of the petitioner. If the appellant shall take steps upon the respondent number 2 by a registered post with AD, as well as by usual process within a week from today. This is matter after 4 weeks.
Yes, my lord.
Item number 6.
This matter may be passed over for time being. The counsel for the respondent is the traffic.
Time being. Okay. Next.
Item number 7.
May it please, sir?
Yes.
My lord, this is an application under section 415 of the BNSS.
Yes.
This is arising out of impugned judgment and order dated 28/7/2025, minor annexure 2, page 45. As a matter of fact, my lord, the learned Chief Judicial Magistrate, by order dated, my lord, at page 20, the appellant was acquitted in the learned court below, but the opposite party number 2 has preferred appeal before the district and session judge court. That is annexure 2, page 45. So, my lord, the fact of the case is that when my lord, the learned court below's order is revised or altered, in the appellate authority, that is district and session judge, has to, my lord, it is a settled principle of law that it should be fresh evidence should be taken, but it was not taken, my lord. This is one of the major defect or error passed by order passed by the learned district and session judge.
So, learned district and session judge, according to you, has
Yes.
passed the order of conviction based on the evidence already adduced by the chief
Yes,
judicial
my lord.
magistrate.
Yes,
And according to you, that fresh evidence should be adduced.
yes. Which has not taken, my lord.
So,
My lord, London CGM has already acquitted me from the charges.
okay. And the learned session just saying that the evidence adduced by the prosecution witnesses were not properly appreciated by
Yes.
the chief judicial.
Yes, my lord.
Okay.
So therefore it needs, so my lord, my grounds are only four, my lord.
Hmm.
A, that is the impugn order of conviction passed by the learned district and session judge has completely abused and accused the judicial power in a cryptic manner in passing the said judgment, madam. That is 27/7/2025 by convicting the appellant and sentencing 1 year rigorous imprisonment and to pay fine of rupees 10,000 or further in default debt imprisonment for 3 months. In appeal number 02/2024 bracket Z without following due process established under the law. So in view of that, the impugn order is liable to be set aside and quashed. B is that, my lord,
So according to you, where the witness is to be recalled, witnesses are to be recalled by the session judge.
yes, my lord, which was not done.
For taking evidence of the prosecution witness over and again.
Yes. And then and only
Evidence- Evidences were already there.
but even then,
It was not
But-
properly appreciated by the CJM.
it was thoroughly examined and all the available witnesses were examined.
And based on the available evidence adduced by those prosecution witnesses, only he has been convicted. Found that there is a case.
No, my lord, learned CGM has acquitted the accused person after going
And
through the
then,
all evidence.
Session judge says that not properly appreciated.
And for that, my lord, the press evidence is required, which was not done for the reappreciation of the evidence. This is only my major plea before this Lord's Matter.
Yes.
Okay, Lordship, with the motion said, Lordship, notice may be issued, Lordship, and answer may be called for.
Go through the judgment properly. Okay. Third, Mr. Pearson. When this judgment was passed?
On 27/7/2025.
It was filed on time.
Yes, ma'am.
Learned counsel for the applicant. This is an appeal. This is an appeal. By filing this appeal under section 415 of the BNSS 2023, the appellant, the challenge, the judgment dated 18/8/2025, passed by the Court of District and Session Judge, Lower Subansiri District 0, whereby the appellant has been convicted for her own passed by the District and Session Judge, Lower Subansiri District 0, arising out of the criminal appeal, number 02/2024, within bracket Z, corresponding to 0 PS case number 05/2020 under section 341/325 IPC, and GR case number 13/2020, whereby the appellant, where is the operative portion, where he has been convicted for offense under section 325 and sentenced to undergo a rigorous imprisonment for convicted and sentenced to undergo rigorous imprisonment for
1 year.
offense. Just for 1 year,
1 year.
undergo 1 year rigorous imprisonment for offense under section 325 and fine
Of rupees 10,000.
10,000 with default clause. So your ground, probably you may have to relook. Okay, anyway, the appeal. We'll admit the appeal.
That's it.
The appeal is admitted. Call for the trial court. Issue notice. Since Ms. Elhage, additional PT, has appeared and accepted notice on behalf of the state respondent number 1. No formal notice need be issued to the said respondent staff. The appellant shall take steps upon the private respondent number 2. By it has to be by registered post only.
Yes, that's it.
Okay, with AD as well as by usual process within a week from today's start. List is matter after 4 weeks.
My lord, my small prayer, my lord. In the meanwhile, my lord, interim. I have not
There is
made
no
a prayer, my lord.
There is no interim period.
I have not made.
Hmm?
In the prayer, my lord, I have not made a prayer, my lord.
You may have to file. You
Sir.
file one IA.
Yes, my lord.
Okay.
Obliged, my lord.
Item number 8.
Oh, my lord. This case.
My lord, sorry to intervene, my lord, the share is yet to be received, my
Okay.
lord.
I think there is PCR report. Yeah. Is this trial for the court? Who is correspondent number two?
Not appearing, my lord.
My lord, on the last date,
What is this? It's received.
yes, my lord, it has received, and on the last date, it was agreed. Since the complaint was filed in the capacity of, in the official capacity. So therefore, my lord, his presence may not be necessary. Just to fulfill the procedure, my lord, we have taken, we have arrayed him a party and we have taken step. Notice has been duly served. And just to recollect our memories, on the last date, the state government's council was also there, and they say that may not be required. Since the main case is with the SIT, my lord. And my lord has called for the reports of the trial court reports. As my friend has submitted, whether it has come or not, we don't really sure.
Yes, this is 23 only. This is the record you have received.
You have received.
My lord, but I failed to find in this office noting, my lord.
We can.
You want to see? You want to go through
Yes, my lord.
tomorrow?
Tomorrow, my lord.
This matter. I'm there, my lord.
Okay.
Yes, it can be fixed tomorrow.
Okay. We'll take up this matter then
My
tomorrow.
lord.
My lord. It was.
Record is there, huh?
Yes, it was agreed on a last date, my lord, though it is, it has come for an admission. We will make an attempt to dispose of this matter, my lord.
Yes,
On the last date, it was agreed in that way, my lord. So, we will,
but you see,
my lord.
the charge was framed
Yes, charge is
against the
framed.
accused persons,
Yes,
and probably the Session Court has
started the trial also, my lord, and
exhaustively discussed
yes, my lord.
and then found that there is a material, prima facie there is a material.
That is a problem, my lord. There is no prima facie material, my lord. The law says that, my lord. Grave suspicious and
Yes.
mere suspicious, my lord. The learned SIT judge went on to frame charges on mere suspicion, my lord. There is no prima
No,
facie case.
on mere suspicion,
Yes, my lord.
charge cannot be.
Yes, exactly. That is,
But
that
then,
is
but then
where,
you see, he
Yes.
has made an observation probably
my lord.
that there is a prima facie
The prima facie, my lord.
case against, case found against the accused for commission of the alleged offense.
No, it is
On
not.
material, there is a material.
My lord, what did the learned as SIT judge said is he found a collective, my lord. The collective, he says that there is a, he found in a very
So,
generic,
when
my lord.
order,
His findings
lord,
are very
if-
generic.
Matter is taken up tomorrow, my lord. We can.
Yes, we'll finish.
Okay, then,
Yes.
you also come prepared then?
Yes, my lord.
Yes,
We'll take this matter,
yes.
take up this matter tomorrow. Okay, A is prayed for by, okay, Mr. M. Rat, you are Mr.?
I'm Yobin, my lord, P. Yobin.
Okay. G. Yobin, Lana Council for the applicant. He is present. Mr. Kudu, Lana Special PPS IT. Praise for some time. And praise for listing this matter tomorrow, to which Mr. Yobin, Lana Council for the applicant has no objection. Prayer allowed, list this matter tomorrow.
My lord.
Tomorrow.
Okay.
Obliged.
Obliged.
No, just a minute. Probably tomorrow's matter, cause list already prepared. And day after tomorrow,
My lord, my flight to Delhi is booked for day after tomorrow already,
Okay,
my lord.
tomorrow.
So, tomorrow, my lord, in the supplementary, my lord. I'm deeply obliged.
Obliged.
this is item.
My lord, this
8 to
item numbers, my lord, these are connected matters, just so.
8 to my lord, 24, my lord. 8 to 24, except item number 23, my
23
lord.
is not there, my lord.
Except item number 23, my lord. 8 to 24.
8 to 24, except 23.
Okay,
Except 23 is not our case, my lord.
okay.
Item number 23.
Item
23, Lord.
23.
Lodge.
Yes.
My lord have already heard this case in length.
When?
Thereafter, AAG was called for assistance.
Hmm?
Earlier order, AAG was called for assistance.
Okay.
Inter-village territorial court is being challenged.
Okay.
It has been already heard in length.
Whether AIG is.
I have given the
Additional-
copy and all, everything to him.
He is present? No.
He's there, he's coming. My lord, I have already also prepared a written argument. Can I
Yes.
submit? Dada? My lord, as in, my lord.
What was the question where the assistance of the AG was required?
My lord, actually, my contention was
Hmm.
the inter-village territorial court,
Hmm.
without there being any notification from the government, constituting their jurisdiction, their appointment, their power and function, they are usurping the earlier Bango level system. They are usurping the power of inter-village territorial court. Therefore, I am saying it's non-est until government notifies.
This is under,
Notification is under section 11 of 21 Act. Government should notify under section 11.
amendment of section 44.
No, 2021 APCC Act.
Okay, just a minute. Huh? Okay, this is 23. 11,
Yes, Your Honor. Yes, my lord.
local limits of jurisdiction.
I have already, my lord, submitted a judgment, two judgment. One is on Bango level system, WPC 255, wherein Bango level system has been declared non-est since AFR doesn't have any provision for Bango level system.
Which one?
2016 to WPC 255, 2016.
There are 7 and 8.
para 7 and 8, my lord. May I read your?
Yes. Yes.
Under Assam Frontier Administration of Justice Regulation 1945, the village authority has been recognized as one of the forum for resolving the civil disputes. Apart from village authority, the assistant commissioner, the deputy commissioner, and the high court, there are no other forums recognized under the AFR 1945 for resolving the land and river dispute between the parties. In view of the matter, I find that the Bango level cover could not have assumed jurisdiction to decide the disputes between the petitioner and the respondent, and accordingly, the impugned Bango level cover decision dated so and so in hereby quashed and set aside. Thereafter, my lord, 2021 Act came, 22 Amendment Act came, wherein Inter-Village Territorial Court has been recognized. In spite of that, there is another judgment from this coordinate bench, that is WPC.
So, but by this act, inter-village territorial
Has been recognized,
recognized.
yes, but not notified, not notifying, constituting their jurisdiction, power functions. It has not been done yet. But
Okay.
the earlier Bango level system, which was declared non-est, is usurping the power of inter-village territory court without there being any authority.
Okay. Now, according to you, that they doesn't have a power unless
Yes.
there is a notification by the government.
Yes, Your Honor. Yes, my lord. And you,
So here is a case where the Bango level Keba has settled the matter.
here
in
is
this
a case where, yes, Bango level Kaba has decided against me, whereas in village level Kaba, it was decided in my favor.
Okay.
They have reversed the decision.
So the Bango level Keba, according to you, cannot decide
Yes,
unless
don't
there
have-
is a notification by the government.
yes,
So the question, whether the Bangolebe Keba, it was here in the case, Bangolebe Keba has decided. According to him, unless there is a notification, although there is a act, as per the act, they have been recognized, but then unless there is a notification has not yet issued. Unless there is a notification, they doesn't have a power to decide the matter. So
Well-
here your assistant would be required.
Yes,
right?
my lord.
Any notification?
My lord, earlier,
Hmm.
before coming into force of the Civil Courts Act,
Hmm.
AP Civil Courts Act,
Hmm.
there was, it was only under the AFR.
Yes.
It was followed. Under the AFR, there was no concept of Bango level Keba. It only says, said under section 5 that it is the village authority
Hmm.
appointed by the deputy commissioner.
Yes.
And a member of a village authority can be a village authority of one village also, several villages also. That was the definition. Means a Gaubura could have been appointed by the deputy commissioner for one village also, or many number of villages. A single person. He could have been appointed for one village and another village also. That was the definition. Now, after coming into these all judgments, these are prior to the coming out to of the AP Civil Courts Act. Now, in the AP Civil Courts Act, the concept of customary court that has been given, my lord, the customary court has been defined. If my lord comes to AP Civil Courts Act, yes.
Hmm.
In definition, my lord,
Yes. D.
2B, my lord, civil courts means a court of district judge, a court
Two.
2B,
Okay. Yes.
a court of an additional district judge, a court of civil judge senior division, a court of civil judge junior division, or a customary court, including village authorities by whatever name and name called under the Assam Frontier, so and so, so and so. Then D, 2D,
Hmm.
customary court. What it says? Customary court means a traditional council or authority of a villages, indigenous to the state by which whatever name called, and includes a court of village authority under section 5 of Assam Frontier Administration of Justice Regulations. Now, this customary court here, what the term is used is traditional council or authority of villages. Now, this is under the AP Civil Codes. This was in 2021. Now, although customary court was defined here, but in the Assam frontier regulation, my lord, the definition remains same. What is the village authority? Because although this in 2021 this was this definition was given, but if my lord says this definition was not similar to the definition in the AFR. Under the AFR, what initially the village concept of village authority is it was very simple. Under section 5, the village authority was not defined as such. Only the wording was that under section 5, if my lord says AFR section 5. 5.1.
Yes.
My lord will just keep in mind that although customary court was defined in the Civil Courts Act 2021, saying that traditional village council or village authority, but that definition was never there in the AFR.
Hmm.
And at that point of time, the AFR only simply said that the deputy commissioner shall appoint such person as he considers to be the members of a village authority for such village or villages as he may specify and may modify or cancel any such order of appointment and may dismiss any person so appointed. Simply, it gave the power to the deputy commissioners under section 5 that a person can be appointed as member of the village authority. Now, this AFR was amended only in the year 2023. My lord will see if my lord has the amendment of 2023, the Assam Frontier Administration of Justice Amendment.
2023.
Yes.
Yes.
In section 3,
Yes.
3.1, amendment of section 2. Here, by amendment, the first time the concept of village authority was introduced, my lord. If my lord will seek section 3, clause 1, amendment of section 2. In the principal regulation, the clauses under section 2 shall be arranged as under. If my lord just compares with the original AFR, there was no serial numbering.
Yes.
First, it says administrator, then pleader, deputy commissioner, the tracks. This has been arranged and given serial numbers, my lord. Clauses A, B, C, D. A, administrator, then B, heinous offense, C, pleader, D, deputy commissioner, E, the tracks. These are the paragraphs of the earlier original AFR. Now, after E, what in section 3.2, it says, in clause A, in section 2, for the existing entries, the following shall be substituted. A, state government, government means government of Arunachal Pradesh. Then B, in section 2, in clause E, the definition of the word tracks, the definition of the words district means a district of the state of Arunachal Pradesh shall be substituted. Then after clause E, the following shall be added, namely, first time F has been added, my lord. Village authority means members of traditional village council or inter-village territorial council or apex council by whatever name called, including head Gambura, head Gamburi, Gamburi, and traditional village head. My lord will kindly take note of that traditional village council has been mentioned means members of traditional. It says members of traditional village council or inter-village territorial council or apex council. Members. And one more peculiarity will be traditional village head is also there. My lord knows in our state, many of the tribes, like the Thangsa, Noktes and all, they have traditional village head. This provision is traditional village head is in such, for such tribes where there exist traditional village heads. Rest, there are practices like traditional village councils. For example, in the Adis and Galo, cluster of villages, they have a name common, this Bango, because of their common customary practice, traditional practice and all. They have they are in clusters which we normally call Bangos. And their inter-territorial councils are also there. Apex council are also there, like Bogum Bokak Keba. Means entire Adi and Galo will abide by these rules. These are not in any enactment, but these are just practices which are being customary practices which are being followed, my lord. Now, after this definition, there is an amendment in the section 5 of the original AFR. My lord. If my lord comes to the second page, my lord, section 5, amendment of section 5. Here it says, in the principal regulation in section 5, after subsection 2, the following subsection and explanation shall be inserted, namely, excuse me, 3, the state government may frame rules and guidelines for all or any matter as may be deemed expedient, including election, selection, appointment, powers, functions, and meetings of head Gambura, head Gamburi, Gambura, and Gamburi. State government may, for election, selection, appointment, for Gambura, Gamburis, direct. It doesn't say village authorities. Direct Gambura, Gamburi. Now, then explanation. For the purpose of section 5, village authorities shall include members of traditional village council or inter-village territorial council or apex council by whatever name called as defined in clause F of section 2, and the head Gambura, head Gamburi, Gambura, Gamburi institutions. The members of, then it comes, members of traditional village council or inter-village territorial council or apex council shall be determined by head Gambura, head Gamburi, Gambura, and Gamburi. I'll stop till here. Who will be the traditional village council or inter-territorial village council? Deputy commissioners will appoint Gaon Bura, Gaon Buris. Head Gaon Bura, Head Gaon Buris, Gaon Bura, Gaon Buris. Now, to decide the who will constitute a territorial village council or inter-territorial village council will be determined by the Gaon Bura, Gaon Buris. I'll make it clear later on, Madam. Why? Because the Gaon Buras and Gaon Buris of different villages, if they are in a cluster, Madam, they will know better that these villages we are in a cluster means so to say a bango or this bango of this village constituting 5 villages or 7 villages. They will determine that we are in the same bango. It is as per this. It is not the deputy commissioner who will say that you all will be a village council, territorial village council for this area, this Gaon Bura. It will be determined by the Gaon Buras themselves that we belong to one cluster. We determine we are in which village council. Inter-territorial village council also. They will determine. To my understanding, Madam. And then, although the word apex council is there, we cannot assume that the apex body like the ABK or GWS or NES, so whatever the apex body, they will be functioning as the inter-territorial or village authority or village council or apex council. It will be only from within the Gaon Buras, so appointed under Section 5 by the Deputy Commissioner. It cannot be interpreted to mean that the society head of any tribe, they will constitute the apex council. It cannot be interpreted in that way. Those are not appointed by the Deputy Commissioner. Here, it will be, to my understanding, it will be the Deputy Commissioners, the persons who the Deputy Commissioner have appointed as Gaon Bura, Gaon Buris. They will constitute the apex from amongst themselves. They all, if it is for entire tribe, then the entire Gaon Bura and Gaon Buri will constitute the apex head, apex council. It cannot be said that a single person from amongst the Gaon Bura or Gaon Buri will become the apex council. They will have to be in totality constitute the apex council. Likewise, inter-territorial also, those interested persons who are in the territorial jurisdiction, they will constitute the Gaon Buras of those villages will constitute the inter-territorial village council. And likewise, the traditional village council. So that is why, my lord, it says that determined by the head Gaon Bura, Gaon Buri, Gaon Bura, Gaon Buri. It says it will be determined by the head Gaon Bura, Gaon Buri. And thereafter, this is a bit different. The traditional village head, what it says, as per the traditional customary laws and practices, here it is a bit different for village head. As per the traditional village head, as per their traditional customary laws and practices. Meaning thereby, the Deputy Commissioner never appoints any head, village heads in some tribes, my lord, it will be as per the traditional customary laws. My lord, got it, my lord. Here under the customary code, two types of village heads and village councils, my lord. One is village head, one is village council. From the village council, inter-territorial village council and apex council. That is another thing. The appointment of this council will be by the deputy commissioner because they are basically the Gaon Buras or Gaon Buris appointed under Section 5. Now the village head is not appointed by the deputy commissioner. It is as per the traditional customary law.
Yes, no notification is required correctly.
Yes. So no notification, and thereafter it clearly says the Gaon Bura, Gaon Buris shall be appointed by the deputy commissioner of the respective districts. We have to, although it's not very sweetly worded, a bit cumbersome, but the intention of the legislation has to be understood, my lord. It should.
It appears, because in the last paper shall be appointed, Bura and Gaon Buri shall be appointed by the deputy commissioner of the respective district.
Yes. And what it says, the village, traditional village council, village council, territorial council or apex council shall be determined by the Gaon Bura, head Gaon Bura, head Gaon Buri. Because it is amongst those Gaon Buras and Gaon Buris, they will determine their jurisdiction that we fall under this Bango. I am a member of this village, I'm the village authority of this village. We cluster of village, we are under one Bango. So we villagers, head Gaon Buras of these villages, we constitute the territorial village council. So
Yes, where from it says that this needs a notification of the by the government.
My lord, for that, my lord.
Although what it says is not very happily worded, but then of course it appears.
Yes.
This was what we are normally it is understood.
My lord, in bit consonance with our learned AAG.
Yeah.
The word is among those Gaon Buras from different villages. They will determine who will be their head of inter-village court. They will determine that shall be appointed by the deputy commissioner. Because Section 5 is already there, AFR, wherein Gaon Buras are appointed. In existence of Section 5, why this
So
subsection
the
has
last the sentence that shall be appointed by the deputy commissioner of the
Yes,
respective district.
yes, my lord. Meaning
So
thereby those
this
determine
addition is
among them.
confusing.
Gaon Buras, Gaon Buris, all what I'm saying, Gaon Buras and Gaon Buris are obviously to be appointed under Section 5 of by the deputy commissioner. Now, with regard to the village council, traditional village council or inter-territorial village council or apex council, who will appoint? That I'm addressing, my lord. Appointment, because the members will be from the Gaon Buras and Gaon Buris. Appointment will be done by the deputy commissioner. But who will constitute? Because it
In
will
the beginning, the sentence started for the purpose of Section 5. Village authorities shall be included.
members of traditional, says members of traditional village council or inter-village territorial council or apex council, by whatever name as defined in clause 5 of Section 2, and head Gaon Bura, head Gaon Buri, Gaon Bura and Gaon Buri institutions. members. The members of, then the sentence starts, the members of traditional village council or inter-village territorial council or apex council shall be determined by. It says determined by.
Head Gambura, head Gamburi, head
Yes.
Gambura, head Gamburi, Gambura and Gamburi.
Gamburi.
And a traditional village.
Then next
as
starts
per
with
their
the
traditional
village head.
customary laws and practices. And
The-
head
it-
Gambura, Gamburi. Shall be appointed by. Gambura, Gamburi being appointed by the deputy commissioner under section 5.
Yes.
So that-
They will, those Gamburi who are appointed under section 5, they will decide who will be the traditional village councils. Who amongst them, for certain disputes within a cluster of villages, who are included, they will decide amongst themselves. It is not for the deputy commissioner to earmark that this cluster you will constitute one village territorial council or inter-territorial village council. It will be within them, the Gamburas and Gamburis of the villages. If they fall in that cluster and that bango, they will constitute the traditional village council or inter-territorial village council. Like, and then apex council also, what I've already stated, that all, if it belongs to the one particular tribe, for example, the Adi tribe, then it will not be confined only to the jurisdiction. It will of the Adi inhabited areas. It will have to include all the Gamburas within the Adi tribe. So I believe because we'll have to harmonize the intent of the legislation, madam. As I've already said, it's not happily worded, but intention is to have that practice. Earlier, it was being practiced in the name of Bango level, district level, Keba, all this. Now the name has been changed. Inter-territorial, traditional village council. Because practice used to remain. It was not there in the earlier AFR. But now it has been incorporated. We have to give some meaning, the intent.
Still, do you have a doubt in it? Yes, what is that?
My lord, WPC. Okay. 314 of 2019, which was decided on 18th April 2022, wherein at paragraph 4, 5, these guidelines all been reflected.
WPC?
WPC 314 of 2019. My lord, I have already submitted earlier. Must be there in the record. My lord, above it's written Supreme today AI.
Okay, Supreme today. 2032. Supreme Court, okay. So,
For my lord's better understanding, may I read?
yeah,
paragraph
okay,
four?
WPC 349.
Yes,
Okay, para 4, 5.
yes. This has been passed already in enforcement of 21 and 22 Act of APCC. The respondent number 3 in his affidavit in opposition stated that the Bango level cover system is not only prevalent in Galo area, but also in entire Arunachal Pradesh since the time immemorial. And the government of Arunachal Pradesh has recognized the existence of such Bango level system by guideline number so and so 2001. And the same was issued to all the district administration and amongst the village authorities. And the deputy commissioner, Lepara, the district basar, is within the competency and permitted under the guideline and report the suit to Bango level Kava. And as such, the order of Bango level Kava cannot be questioned in writ petition. 5, paragraph 5. In their affidavit in opposition by the respondent number 4 and 5, it is stated that village level kaba, Bengal level kaba, and district level kaba are the practice and convention being followed by Adi Galo tribe to resolve the disputes in between themselves and the Kaba decision. That so and so was taken on fairly on merit and witness and submission of deponents were not taken care of, and as such, the matter is agitated before the ADC Basar, who has directed for holding Bengal level cover to resolve the dispute. Accordingly, the Bengal level convention so. This I am reading this, my lord, because to understand that it has already been submitted that guidelines have recognized Bengal level so. After all these things, what the decision has been pronounced is at paragraph 11. Paragraph 10 may also be read, my lord, would like to read. Though the respondent number 3, 4, 5 tries to justify existence of Bengal level cover in the system of administration of justice in the state of Arunachal Pradesh by referring to a guideline number so and so 2001, yet such a provision is not found available in AFR 1945. It is hardly believable that a guideline issued by government can create a forum which is not recognized under the law. It is an admitted fact that no such provision exists in the AFR 1945 for deciding a dispute by Bengal level cover after a decision of village level cover. Now it is to be seen whether the Deputy Commissioner Laparada district can confer jurisdiction upon a forum which is not in existence under any provision of the law. Paragraph 11, my lord. While dealing with the issue, Honorable Supreme Court in case of Jagmitar Sen Bhagat versus Director Health Services Haryana and others so and so in paragraph 9 held that law does not permit any court, tribunal, authority, forum to usurp jurisdiction on any ground whatsoever in case such a authority does not have jurisdiction on the subject matter. For the reason that it is not an object as to the place of suing, it is an objection going to the nullity of the order on the ground of want of jurisdiction. Thus, for assumption of jurisdiction by a court or a tribunal, existence of jurisdictional fact is a condition precedent. But once such jurisdictional fact is found to exist, the court or tribunal has power to decide on the adjudicated fact or facts in issue. It is also held that undisputably it is a settled proposition that conferment of a jurisdiction is a legislative function. It can neither be conferred with the consent of the parties nor by superior court. And if the court passes a decree having no jurisdiction over the matter, it would amount to nullity as the matter goes to the root of the cause. Such an issue can be raised at any stage of the proceedings. The finding of a court or tribunal become irrelevant and unenforceable, inexecutable once the forum is found to have no jurisdiction. Similarly, a court tribunal inherent lack jurisdiction, acquiescence of party equally should not be permitted to perpetuate and perpetrate, defeating the legislative animation. Thereafter, paragraph 12, my lord. A coordinate bench of this court in WPC 255, it has been referred earlier judgment which I have already submitted. What I'm here therefore submitting, my lord, is there was Bengal level system earlier which was held non-est by this court. Thereafter, AFR 21, APCC 22 come, wherein it has been recognized, referred as inter-village court. But those Bengal level system which are in existence, which has been held to be non-est in the law, is now on their own usurping the power of inter-village territorial court without any sanction, any notification. That is my submission. And as per section 11, the government may notify or fix their territorial power, function, election, selection, all these things are there, my lord. Number 3, my lord, section 5 AFR is already there, wherein village gaumburas are appointed. In existence of that, without deleting that or without superseding that, why this section 5 subclause and explanation has been added? The intent of the legislature is to facilitate the appointment of inter-village territorial court. Therefore, in section 5 explanation, it is always said, already said that those village gaumburas, head gaumburas from various villages, they will determine among them who shall be the head of their inter-village territorial court, and which have to be appointed by the deputy commissioner. The language is, to my humble understanding, because or else why these line and
Last.
line has to be added. It is added to.
The last line has
Yes.
confused him.
That's the intention of the legislature.
Yeah. Just a minute. See, the explanation it appears, see, till this. And it is only the Gamburis of the village who would decide the territorial council or apex council. It is clearly mentioned here and then clearly stated. Of course, last line, what you are confused about is that, and the head Gambura, Gambura and Gamburi shall be appointed by the deputy commissioner of the respective district. This is talking about section 5.
My lord, may I simplify? Because
Yes. This-
there are three parts.
Yes, 3 parts.
Explanation. First, I'll just part wise. For the purpose of section 5, village authorities shall include members of traditional village council or inter-village territorial council or apex council by whatever name called as defined in clause F of section 2. My lord, till here we and the head Gambura, Gambura and Gamburi institutions. This is, it says shall include village authorities shall include traditional so and the head Gambura and Gamburi institutions. Then thereafter, my lord will read the fourth line. The members of traditional village council or inter-village territorial council or apex council shall be determined by the head Gambura, head Gamburi, Gamburi. We'll stop till here, my lord. My lord, we will stop till here. We'll take it as a sentence.
Yes.
It will simplify, my lord.
Mm.
Till Gambura, Gamburi.
Yes.
Then we'll start again because it says determined by the head Gambura, head Gamburi, Gambura and Gamburi. We'll stop till here. The confusion will go. And the traditional village head, as per their traditional customary laws and practices, and we will stop till here, my lord.
Yeah.
It has differentiated the inter-territorial council and the traditional village head. It says traditional village head as per the customary laws and practices. We'll stop till here. Now, thereafter we'll start, my lord. The head Gambura, head Gamburi, Gambura and Gamburi shall be appointed by the deputy commissioner of their respective districts. That makes it clear, my lord. It is obviously the head Gambura and Gamburis will be appointed by the deputy commissioner of the respective districts. Now, 3 parts. 1, traditional village council, then the village head, then the Gambura, Gamburi. With regard to traditional village council, it clearly says that it shall be determined by the head Gambura, head Gamburi. The village head will be as per the customary law and practice, not by the deputy commissioner. Traditional village council by the head Gambura, Gamburi. Then lastly, the Gambura, Gamburis shall be appointed by the deputy commissioner. If we take it in parts, then the meaning comes out. Otherwise, continuous reading the lines together, the 3 sentences together, it creates a bit of confusion. But ultimately, the intention is as such, man. Because we have to harmonize. If we mark it in 3 parts.
Yes.
So, my lord, with regard to whatever my learned brother has submitted, I'll not, those were judgments prior to the amendment of this AFR.
When this judgment was rendered?
Delivered on 18th April 2022.
18?
April 22, those are,
2022. Okay. So this was prior to the amendment only.
Yes, AFR amendment prior.
Okay, then,
But in existence of APCC 21 and 22.
in any case, that's why in the beginning I
so
said,
this has come after 23 only.
yes, 23.
Yes, I think it's clear.
So
Because
after,
this was the understanding, normal understanding. And then you try to interpret this way, and then solve this way, the judgment disputing that, including the last also continuously reading,
yes,
and then interpret it and try to interpret that according to this, the deputy commissioner is to notify by appointing this.
the Gambura Gamburis. Gamburis, they will determine the traditional village home.
Probably, are you still confused or are you clear? Are we clear?
No, number one, my lord, the members will be determined among them. That is accepted.
Yes.
They will determine among them
One
the
more
members of-
confusion.
The members who determine among them, these among them are being appointed by
No,
deputy
members of
shall be appointed
intervillage
by deputy
territorial court or customary court shall be determined by the head Gambura, head Gamburi.
Yes,
They will determine.
Hmm.
And thereafter, the last line
Not
is
after.
appointment.
not after. Okay.
Those determined members shall have to be appointed by the deputy commissioner.
No, no,
making
those,
them as
those
intervillage-
persons who are there, already there, they are being appointed by,
No, they are
or they will be
Gamburas and
appointed by the
Gamburas.
deputy commissioner. They are already being appointed.
Yes, already
appointed.
being appointed, my lord.
Hmm.
Already being appointed. Thereafter, this amendment 23 comes.
That because
Amendment
in the
23,
beginning,
the intent
in
is-
the beginning, it didn't say that this Gambura, because it, you want, you mean to say that the Gamburi shall be appointed by deputy commissioner, and thereafter this would come.
That is,
It would have been clear for him.
my lord, Gamburas and Gamburis for
But
villages.
then it's all the
Fake,
same.
fake remains the same.
Fact remains the
Because-
same only.
First, the Gamburis will be appointed by the
Yes.
deputy commissioner.
Hmm.
Now, amongst these Gambura and Gamburis, they will
Yes,
constitute
that's
a-
understanding.
territorial village council. It is not one person who will be appointed amongst them to constitute a council. It will be amongst all these Gambura and Gamburis who will constitute. My learned friend is assuming that amongst them, they will select one who will be the traditional village council.
Not
It's
only
not
one, not only one, all the
It will,
members.
they will, together constitute the traditional village council. They will determine who villages, the Gamburas of which village will constitute the traditional village council. That is the interpretation.
My lord, as a last submission,
Yes.
section 5 AFR for village, for one village. Suppose, for example, for Darka village, section 5 appoint head Gamburas and all. Thereafter, 5 another village, section 5 appoint. In existence of that, inter-village came, this territorial court concept of this came. Thereafter, this amendment arrived. Here in this amendment, that section 5 of AFR has not been done away. But this is supplementary provision has been added, whereby the intent is to facilitate the appointment constitution of inter-village. Therefore, suppose there are 4 or 5 villages within a territory which is functioning as a inter-village court, like earlier Bango, they are still functioning. So what they do is they constitute among themselves as a Gambura association, welfare association. Thereafter, they appoint a
So
president.
that you mean to say that the deputy commissioner will appoint 2 set?
Yes, Your Honor. My lord.
No, I think
Because-
that's not the intent of the, probably.
Because
After this, Assam Frontier, after this amendment, probably, and then for appointment, and after this implementation of the Arunachal Pradesh Civil Court, then the Deputy Commissioner or ADC doesn't have a power. After appointment, only their power is to appoint the Gambura under Section 5.
yes. Among them, they will again select the members of inter-village among
No,
them.
Then
They will-
the role of the deputy, it's not the role of the Deputy Commissioner or ADC.
No, not role, my lord. That I agree.
Hmm.
But those Gamburas and Gamburas, they
Yes.
will select among themselves,
Among themselves.
determine who will be the members of inter-village.
Yes,
That has to be appointed by the
No.
deputy commissioner.
then again
That
reappointed.
language is,
No, that is, he is
Last
coming
line.
back again.
because it's otherwise, why need
No.
of this adding this last line that shall have to be appointed by the deputy
So
commissioner?
it should have been in the first line. the Gambura who have been appointed under section 5 will appoint, meaning they are, isn't it?
This makes us confused.
It's a grammar,
did-
of course.
Be that as it may, my lord, for challenging the Kaba decision,
Mhm.
lots of provision has not been followed, it has been violated.
Okay, I think this probably, this part is clear, because
Yes,
this
ma'am.
was normal understanding only.
Yes, my lord.
When he tried to create confusion, so that is why your assistant was required.
Yes, my
And
lord.
it appears that it is clear only.
Although not
Therefore, your
happily
lord,
worded, I
because-
said,
Hmm.
although not happily worded, but
Yes, that is,
it-
My lord,
because this
now,
grammar
yes,
only.
yes.
Uh,
it should have been in three different parts.
three different parts, or otherwise semicolon,
Yes.
semicolon, and then the last,
Yes, yes.
could have been.
My lord, may I take
Please.
your leave, my lord?
Thank you. Thank you.
God bless you.
and now
Now-
coming to the Kaba decision, my lord,
Yes, so now we can come to the case. So today it is for
or legality of inter-village territorial court
inter-village. It has been listed for order,
admission.
admission, okay. So you want this lengthy hearing or just can be?
No,
We
no,
can,
My submission is limited, my
Yes.
lord. Number one,
Hmm.
my prayer is to set aside the decision of the inter-village,
hmm,
and liberty may be given to the parties to approach the appropriate forum,
where is the appropriate forum according to you?
CJM, as per section 9. Chief Judicial Magistrate or
Okay.
Civil Judge,
Just a minute,
Senior Division.
just a minute. Where is the Kaba decision? Just see one. Let
Kaba
us see one.
decision is
quickly.
at page number 53. Translated copy is at 53 of my,
The first Kaba decision?
no, that was challenged in inter-village.
No, the first, where is the first Kaba decision?
First Kaba decision
Let
is
us start.
at page number 33, my lord.
This is West Siang,
Yes, West, yeah.
so Kaba.
Translated copy is at my lord 36. Herein, it was in my favor. This is the
So,
village
36.
Kaba decision, yes.
Just a minute. Okay, let us quickly read what is the in so. Today's and so
Translated copy is at 36,
36.
page number 36.
Who lodged complaint?
I lodged complaint, my lord.
Okay, you are
I'm the,
repay,
yes, petitioner,
repay my,
yes.
okay. Just a minute. Complaint for second time.
Yes, second time.
With the two son of late Mirik Mai. Okay, he declared that whosoever takes care of him, the father,
Yes. My
Okay.
father, the respondent's grandfather.
okay. So the respondent is son of late Mirik Mai. Sorry, no,
No, no, no.
late Ritum.
Yes,
Ritum Mai. So Ritum Mai and the present,
petitioner is brothers.
Hmm.
The respondent are grandson and I am the son. They are
okay.
my brother's son.
But then your brother
Yes,
died before this, before the property was divided.
yes.
Okay. But he and then the son, the respondent inherited your brother,
Yes,
your brother's share. Okay. So now, while you and your brother's son, the respondent, is still alive, the father decided whosoever look after him.
especially two landed property that is in dispute.
Two
The
land-
reca-
rest otherwise distributed. Already
Less
divided.
otherwise it's already settled.
Okay. Two landed property property was still with him, with the father,
Yes.
undivided. Okay.
But if my lord see the cover decision, that land was opened by me. Usually that was a barren land which has been converted into the paddy field by me. Cover decision already recognized that. Therefore, it was given to me with this pawn.
Where is the declaration of the father, of your father?
Declaration
It was
is
made when?
declaration is made in 2022.
22.
It's
And
at
this
it's at page number.
complaint was lodged on 25.
Now that there then also I lost complaint, but it was not taken into account by the head Gampura. And thereafter he was also not claiming. So I thought he has waived his right. Thereafter in 2025 he started.
No, the lane was under your possession according to you.
Yes.
Shall we do then?
2022 they made declaration within
No, whosoever Kesari Kiran, and whosoever takes care of Srimati. So who is Ibom Mai? Ibom Mai.
Ibom Maya is my mother.
Okay. So the whosoever takes care of father will get Kesari care,
Yes.
and whosoever take care of mother will get Gogiri care.
Gogirike and Lidirike.
Gogiri, okay, two property
Yes.
for the person taking care of mother.
My lord, I am a government servant. In police, I usually go in transfer and posting in various places.
Okay.
And I have already, that is also recognized by
Just a
Kava.
minute,
I have already bear the expenses of the respondent since
Yeah.
they have no father. I have taken all the responsibility. Considering that, Kava had decided in favor of me. Thereafter, they appeal
In
before the,
favor, in your favor.
yes,
Okay, the Keva decided in your favor.
yes, village level Kava. That has been challenged in,
Just a minute. The state declaration of draft. This was drafted by who? Who is this Nyoge Mai?
Nyoga Mayu is a village elder. My lord,
Hmm.
in total, we have 8 landed property from our father. From that, 1 has been equally divided, 4 has been given to respondent, 3 has been given to me as per this decision. But the Bango level decision, the inter-village decision, has only given me 2 landed property and 5 landed property to him, to the respondent. All these things apart, my lord, in CRP, the scope is limited.
You are retail. So you said that the entire property was divided except this Gogi Rike and Lidi Rike, Kesari Rike, Gogi Rike and Lidi Rike.
Actually, not divided.
So-
We understood that, okay, he
That
will
was
take
giv-
that, I will take that.
Okay.
This was understood.
Okay.
But my father, in
So,
my absence,
As per this Keba, page 36, this Kesari Rike goes to whom?
as per page number 36.
Kesari Rike is for
Kesarika
this
is,
is property
well,
distributed.
a paisa Kesarika was given to me.
Okay. Okay, Keba not only decided this free property, but they decided the entire property.
Yes. Wherein out of 8 landed property, 1 was equally divided between us, 4 was given to respondent, 3 was given
But
to
the
me.
dispute was only with regard to this free property only.
Yes.
But Keba decided entire.
Yes. That day we decided to directly go for division, since
Hmm?
we cannot go for kebab
No,
all the time.
this was not disputed. This this other rest.
The
of
others is not disputed by him. Only this particular
Okay.
which
So
has been given. to me.
Kesarike, since it was given to you,
Yes.
so he is agreed.
Yes. And
Only Kesarike.
and if my lord see the decision, Kaba has already recognized that this was opened by me, therefore it has been given to me.
Just a
And
minute.
other one was
Kesarike
given to me because,
you are repay my
yes,
because repay my has opened the.
if my lord turn to page number 37, last paragraph, Kesarika was given to Ripamayu because Ripamayu and Ganyamayu have opened the WRC field at Kesarika, which was affirmed by all the Kaba
Who is
members.
Ganya?
Ganya is
He's a
my
party.
relative, yes, friend.
A friend only.
Yeah.
Okay.
He helped me opening that land.
Okay.
And thereafter, it was opened during the lifetime of my father, taking so and so, so and so. And another land was given to me because I have borne all the expenses of respondents in absence of their father as their chacha, uncle. Be that as it may,
So just a minute, one information. So the property instead of deciding the disputed property, here it appears that entire property was re-divided, it appears. So as per this, the disputed property, you don't have any grievance with regards to the other property. Only Kesarike.
Only Kesarike.
Kesarike.
Because
So, but specifically the Kesarike was declared for the person who looks after. So,
yes, look.
so when this complaint was made, whether the father was still alive,
yes, that time alive, when I made first complaint,
okay.
my father made a
No,
declaration on.
this decision is
No,
in
after-
person to the first complaint or the
Second
Second complaint.
Second.
First complaint was not taken into consideration.
Okay.
And after
And,
demise of
and
the
at the
father,
second, at the time of second complaint, whether the father was
No.
still alive.
no, Lord.
The fact is, my lord,
See,
Father
you
died
should have
on
decided
25
while the father was still alive.
you should have, but
Hmm.
head Gambura didn't act it. That time father alive,
No, then you see.
I made a
you have-
complaint, head Gam didn't take action, and neither the respondent was claiming that land. Thereafter, after the demise of my father, the respondent started claiming that. Therefore, I made another complaint. That Kaba take into account and conducted, and that's what decided in my favor. Reason was, I opened that land. Another one was,
No, if you have opened the land, then your claim should have been while your father was still alive and could have claimed that it was opened by me, not by you.
no, I made
And then,
complaint.
and then see the property is believed to be acquired by the father. normally, isn't it? Of course, maybe with the help of the children, but then it is acquired by the father, and the father is the absolute owner unless he give it to his children. Okay, so then you lodge complaint.
Yes.
Where is the complaint lodged by the respondent?
Complaint lodged by me is, first one is at page number 23. And the translated copy is at page number
First
24.
one is 23.
24 is translated copy. That was my first complaint.
No, before death of your father.
Yes,
But this was not taken into cognizance.
before
okay.
that, my 22/6 I also made complaint in 2022 after declaration.
No, that was first complaint.
Yes, 22 first complaint. Thereafter, no action was taken.
Hmm.
And after demise of my father, the respondent started claiming that land. Therefore, I made another complaint on March 3,
Which is the
which
complaint.
is at page number 24. And the first
Okay.
complaint is at page number 22.
So the first complaint was made to whom?
To the head Gambura, same village,
It
my
is,
village.
and in the second complaint,
Second complaint before, same head Gambura.
same.
Yes.
Okay, now I've understood. See, now why should he take cognizance of this when he did not take cognizance of your first complaint when your father was
Was
still
alive.
alive? See,
It was taken cognizance. and
okay. Now this is
decisions are
decision.
taken. Yes.
Okay, where is his against this Kabar decision?
Again, this cover decision, they made
Just a minute.
appeal to the Inter-Village
Hmm.
Territorial Court. And Bango Secretary acted as a chairman.
Just a minute. First complaint on
22/6/2022.
page.
At page number 22 is translated copy. 21 is annexure 2.
Okay. So declaration is at
Declaration
page
is at
it was
page
made
number-
on 22 to
Yes.
22. Okay. So thereafter you made a complaint. This was not taken into
My lord,
cognizance.
it's 2205,
What complaint?
annexure 1, page number 19.
Hmm?
But in type copy, it's
No,
wrongly,
no, that
wrong.
is declaration. That is declaration.
Yes, yes, declaration is at 05.
Okay. And then your first complaint was 22/6/2022.
Yes,
Just a minute. Huh?
within 1 month. To Emur Panda.
Okay. Just take the point. Huh? Yama, take point. Huh? On 28/2/2022, the father made a declaration.
My lord, it's May, 28 May, not February.
Hmm?
28 May.
No, it is
In translation, it is wrongly written as 2.
28/2.
28/5.
It should be 5.
Yes, page 19, the original. But in
Okay.
translation, it's wrongly written as 2.
Okay, on 28/5/2022, huh? The father made a declaration. Okay, page 20, huh? Next. Serial number 2. And on 22/6/2022, the petitioner lodged complaint against the said declaration. That's page 22, huh? then then three, serial number three, para number three. On 3/3/2025, the second complaint was made by the petitioner against the declaration. It was after declaration or anything was made, physical,
This was just to request to dividing the properties
to whom?
to the head Gambura.
Okay, head Gambara, mother was also not alive at that time.
Yes. No.
Okay, with a request to divide the property of their father amongst the brother. Okay. Then next, that is page 24. Okay. Then what is this? 25 Paravana. Okay.
25 is Parwana.
Then thereafter, village.
Thereafter.
Next, para 19/4/2025. The Kaba decided. Kaba decided the matter. So the Kaba divided the property and the disputed land, Kesarike lane, within the Kesarike, which was declared by their father. That it will go to the person who looks after him, has been given to the petitioner. Stop. Para. And page 37. You have to type it. Then, being agreed, the respondent approach. Respondent, where is the respondent complaint?
It's at page 39.
Okay.
Translated copy is 40.
Okay.
My lord, before that,
The-
may kindly see, my lord, the distribution of property 1 to 9 at page 37.
Yes.
I have been given only 1, 2,
But rest,
3. Rest given to him.
no, rest is with you only. Others,
I have only 3, 5 there, 5 the respondent. In spite of that, he is
from out of this 9 property,
there is 8 property. 9 is not in dispute now. 8 out of 8, I have been given 3. There, he has been given 5.
okay. Maybe, but that is not disputed.
That is in dispute now, Your Honor.
No, the
So this
rest,
is the intervillage.
the rest,
The rest is
You
not
are
disputed.
disputing
Only
the others?
disputing, yes, that one.
Hmm?
Yes, sir.
only Kesarike only.
Yes.
Okay. Being now next paragraph, being agreed, the respondent file appeal before the village
Report the head Gambura, Bango secretary,
head Gambara Bangor secretary,
Ubu Bango,
Ubu Bango.
Kotum circle.
On 5/5/2025. Then page 40. Okay. That is page 40. Then thereafter,
Parwana was issued. It's your ECMA.
where is the Bango decision? Page 47.
Bango decision, yes.
Hmm?
At page number 40. 49,
49.
yes. Actually, what happened, Your Honor, on the fixed date, Kaba was conducted, statement was taken, there was 7/6 decision. So the umpire decided in favor of respondent. On that day, it was 7/7, so no decision was taken.
Okay. So,
Thereafter,
okay.
subsequently,
So this was actually decided on 6/6/2025.
no, it was decided on 6/9. But backdated decision was taken.
No, what is this page 47?
Page 47 is, my lord,
An intimation is
it's my
regard-
complaint.
Hmm?
It's my complaint, 47 is. What happened, my lord, on 29 May 2025, Kaba was fixed, everything was done, but the statement was 7-7. Therefore, the Kaba decided that no decision could be taken since it's a 50-50. Thereafter, another Parwana is issued fixing the meeting on 9/6/2025. On 9/6/2025, only those members who are in favor of the respondent, they present and they decided this decision, backdated decision.
Which one? Which one?
My lord, may kindly come to page number 53. This is the impugn decision, impugn order now.
Okay.
Here,
Next para. The Intervillage Territorial Customary Court or Apex Court
decision.
decided the appeal on 29/5,
Yes,
2025.
Kaba was conducted on that day, but no decision was taken. Since it was 50-50, split decision. Thereafter on 6/9, thereafter on 9th June, they gathered
This was decided on
9/6.
25/9, 29/5.
No, Your Honor, on 9/6/2025, they take a backdated decision.
No, this is
Retrospective
the,
decision.
what about this decision, 29/5?
Yes, my lord. What happens, my lord? On 29, meeting was conducted, hearing everything was done. There was a split decision. So they didn't take any decision.
Okay.
Thereafter, they
On-
fixed
on-
another
on-
date.
On 29, same, huh? Continue. On 29/5/2025, there was a split decision. Therefore, the Keba, the Bango Keba did not decide the matter. Thereafter, any complaint?
Thereafter, they have issued a parwana
Okay,
on
thereafter,
4/6/2025. 4/6/2025. That is at page 44.
page 44.
Parwana was issued, fixing the meeting again on 9/06/2025.
Next, Paraha. Thereafter, the Bango Keba issued Parwana fixing next date of the case on when it was fixed,
09/06/2025.
4/2025.
Therefore, I
That is
submitted a
at page-
complaint,
Page 44, huh?
47 page. I submitted a
Again,
complaint.
and then next para, again, the petitioner lodged complaint on 6/6,
Yes, Your Honor.
6/6/2025, saying what?
Saying that they cannot take decision, I will not participate because
Objecting, raising objection to the decision to be taken by the Bango Keba, Bango level Keba
on 09/06.
on 09/06.
Now, my lord, on 9,
On when, where is the final decision?
it is at page number 47, translation is at 53. On this day, 9/09/05/2025, only those in favor of respondent, only those
No,
members
this we have
gathered.
seen, this we have seen. 09,
Yes.
this we have already seen.
No, on 09/06, they take a backdated decision, 29/5.
So when it was taken, you said? 09.
Yes, 09/06,
Okay, then next para, on 09/06,
2025.
2025,
They just pronounced the backdated decision.
the Bango level Keba decided the matter giving a retrospective date
29/05.
on 29/5/2025.
My lord, kindly see page 52. Only those in favor of him present, rest absent. They just pronounced.
According to the petitioner, on, that is 09,
Yes, 09/06.
06/2025. Only the HGBs who were favoring the case of the respondent
On 29/5.
on 29/5/2025 were present and signed
Yes, this
The
is the
decision.
declaration, absence
Fine.
declaration, my lord. I have
The
submitted
final decision.
those who didn't attend. 6 members
Have you
didn't
annexed
attend on
that?
the
Have you annexed?
But this is present, this is, Your Honor, only procured after on dated,
Could have filed by way of additional affidavit, additional document? Cannot,
but my lord, it is apparent here, they have not signed. Even in page 52,
that is there.
they have not signed.
Okay. So then agree by this or this?
Yes, I'm
Okay.
coming as a
Okay.
revision, for revision petition. My grounds is, my lord,
Being agreed by the decision of the Bango level kebab on 6. Where do we find where that 6 date? Where do we
9/6.
find that date?
that day is found in Parwana.
For one,
Last Parwana is at page number,
okay. Page
Your Honor, page 44.
4, okay. By the decision of the Bango level kebab on where 6? Okay, 9/6. This Parwana was issued on 4/6.
Yes,
Okay, 9/6. But then the decision is
decision is taken on
okay.
9, retrospective decision taken.
Okay. Decided on 9/6/2025, signing the same to be decided on 29/5/2025 by the supporter of the respondent, the petitioner has filed this
Mainly, Your Honor, there are 3 provisions of law which has been violated.
application under section 227 of the Constitution of India, related with section 115 of the Code of Civil Procedure. Okay. Yes. So your ground is
My lord,
Among-
as per section 44(1) of A per
among the
1945,
following ground. Section
as per section 44(1)
where?
of 1945,
Okay. Now, where is your ground? Just a minute.
my grounds are at, in my petition
Okay.
from page number 11.
Yes, what is your son? You said
Untung ka petition show
ground at page 11, huh?
page 11.
Okay. Yes, what is your submission? You said
Basically, Your Honor, earlier that the Bango level, they don't have authority to decide.
okay.
Inter-village, they are illegally functioning without any notification. Those are main grounds. And apart from that,
Is it the ground?
yes, that is taken. Apart
Okay,
from
you
that,
have stated on your in the ground.
yes, my lord,
Okay.
from 1 to ground 1,
7.
7.
Okay.
And my lord, there
Anything
are
else?
three more ground. Section 44 AFR prescribed
Okay.
that.
Section ground 1 to 7, huh? Okay.
Then low ground is section 44(1) of AFR provides that it says the Kaba should decide the decision in open darbar in presence of the parties and 3 independent witnesses.
Which section you said?
44(1) of AFR.
Okay, further. In addition, the Land Council for the petitioner submitted the decision of the Bango level Keba was
Village authority decision.
village authority
Yes,
was against the provision under section
44(1) of AFR.
44(1) of the AFR, whereby it is provided that the decision has to be made.
And my lord, section 44,
Where is the section 44?
44 amended
This is
2013.
correct.
A 2003 amendment. It provides that 3 consecutive notice has to be given, that too
Which provides
maintaining the
that
gap of 30 days.
44, where do we find that 44?
2003 amendment.
2003 amendment section?
Oh, sorry, 2023, my lord. Section 44,
23 section,
44.
okay, whereby it is provided that the village authority or the inter-village territorial council or prefect's court, as the case may be,
3 consecutive notices.
may pronounce or take ex parte decision if
Yes.
one of the disputing party does not turn up or remain absent willfully for 3 consecutive times after giving not less than 30 days on each occasion of reasonable opportunity of being heard. But you were heard here in this case.
But Your Honor, ex parte decision, that 9/9 meeting, they have taken retrospective decision.
But then earlier, when it was on where is the date 9? On that day, you were present.
Now on 9, Your Honor, I was not present and 6 other Gamburas not.
No,
present.
29/5.
29 I present. They said we cannot take decision because it's a split one. However, subsequently they
Okay.
decided, catered and
Okay.
take it. took it-
However,
take it
the
in-
Dalani Council for the petitioner was present on 29/5/2025 when the final hearing was done, and on which date there was a split decision, and the Bango level Keba declared that they cannot decide. Thereafter, they have made some appointment.
No, no.
Okay.
Was appointed by
Okay.
No 3 member, Your Honor.
Hmm.
My lord, if you see the decision of, if my lord see the decision of 29 decision,
Hmm.
then those signatories, only 1 member was added, not 3. But on that day, no meeting was conducted. They just gathered, they declared the decision.
Then again, disputed counsel for the petition submits that in the final decision, which was signed retrospectively on 29/5/2025, only 1 member was added, as there was a split decision on 29/5/2020.
That can be,
Fine.
Your Honor, proved from their own parwana or 6 parwana. They already stated that
Okay,
because we cannot take decision on that day. Therefore, again fixing.
okay,
It
okay.
is already
So-
there.
Okay. Yes, then,
Thereafter, my lord, section 24 of 23 amendment.
Hmm.
They may approach civil court if agreed. I'm seeking for liberty to both the party to approach the appropriate forum. Not to reconduct the cover.
not to reconduct.
Yes, my prayer is that section 24 of this amendment 23, AFR amendment provides.
And for the reason stated above, the appellant, sorry, the petitioner approach this petitioner prays for liberty to the parties to approach the appropriate court stroke forum
By setting aside the cover decision, that 29.
and set aside the impugned Kaba decision. Okay. Liberty to parties to approach the civil court under section 24.
I'm sorry for the interruption, Lord.
Just a minute, just his prayer only. It's not a decision.
In fact, it is not in his prayer, Lord. That's
Not
why
in the prayer, but his submission.
submission. Prayer, Lord.
Okay. What is your prayer, by the way?
Prayer is to quash, set aside retrospective impugned cover decision dated so and so,
Okay.
so and so, passed by so and so, and
Okay.
declare retrospective so and so as non-est, and pass appropriate. There is
Okay.
deemed fit and
And,
proper.
and while setting aside the impugned Keba decision dated 29/5/2025, passed on 9/6/2025. Okay. Then yes, now let us record your submission.
Time of which already one.
Okay,
Can it be continued after that?
we'll continue at 2 then. Oh. Okay. We'll continue. This is like a hearing, it's taking time, I think.
Yes, sir.
So, what we can do is, there are other matter also.
Lordship, I'll finish my 5 minutes.
Okay,
If my brother, if he's completed his submission, then my submission would be hardly 5 minutes.
okay.
Lordship, Lordship, here from the day one, Lordship,
Mhm.
I'm trying to concede the mistake that has been committed by the affiliate of the
Mhm.
Lordship, since the jurisdictional issue has already convinced my Lordship that the intervention's territorial customary court is jurisdiction, I'm being aggrieved by the Kavang decision, Lordship. I have filed a thing before the inter-territorial place customary court. Accordingly, the Parvana was issued. Hearing was taken place on 29/5/2025. On that day, decision could not be arrived because of the
Lack
high
of,
decision.
lack of quorum,
Yes.
high
Out of,
decision,
out of 14 members,
because it was to be odd number,
yes, Lord.
but it was
Yes,
even number.
yes, Lord. Accordingly, Lordship, Refervana was issued on 4,
Mhm.
saying that on 29, hearing could not be completed, but decision could not arrive because of the high decision.
Mhm.
Accordingly, next to be heard on 9, after 11 days it was fixed. Accordingly, petitioner filed a representation saying that I will not appear before the next date because there cannot be recover. He has submitted representation note. Then accordingly on 9, by adding 3 cover members, on 9 hearing was done. But
Is it on record, 3 cable member?
yes, Lordship, this is Refervana itself.
According to him, it was only one. By counsel for the petitioner, it was only one, you said.
May I take you to the Refervana? Lordship. Can I speak to page 49 type of just last terror, Lordship. I
49.
yes, page 45, 4.2. Okay.
Okay.
Therefore, to take
No,
fin-
45 is Parvana.
yes, Lordship, because on 29, Lordship, Kavang could not pass any decision because of time is here. So accordingly, this Parvana, Refervana was
No, 45 is, okay,
Refervana
okay.
by fixing next day.
Huh.
Third terror, Lordship. Therefore, to take a final decision on the matter, a rehearing date is hereby fixed. All the Kava members listed below are requested to attend the Kava hearing on 9/6/25 at 8 a.m. at Nitya Bango Community Hall. All the members are requested to be present in the hearing without any fail. 3 new Kava members are hereby added. The case owner are directed to make their statement in the Kava and may present their evidence and witness if any. By this Refervana, Lordship, another 3 new Kavang member was added, and date was fixed for rehearing on 9/6/2025.
Yes.
Then Lordship, representation was submitted by the petitioner at next page, Annexure 12, page 47, saying that I will not attend on recover because there cannot be a recover. Please contention.
Page 47 is objection.
Yes, page 47 is the objection filed by the petitioner saying that no, I am not going to appeal in the recap because there is no provision for recap. This is the objection. But it's in the-
Yeah.
Now, Lord, see, in terms of recover was held on 9. And season was passed expert.
Where is that?
And that is, and Lord, see, interestingly, on 9, decision was passed, but date of decision has been reflected as 29, Lord.
There are difficulties.
Yeah, this is the. Now here, Lord, I am considering from the day one, Lord, I am considering that the ex parte decision was legally passed. Of course, in my favor, it was passed. But this is against the law. That's why I considered, Lord, from the day one. Therefore, Lord, the remedy under CRC, Civil Revision Jurisdiction, is, Lord, was this ex parte appeal order and remanded it back to the affiliate court, Lord,
Okay.
and direct the board of the head governor, GD of Intervallate Territory Customary Court, to giving an equal opportunity to both the parties. And my appeal is to be heard because this honorable court cannot decide my appeal as illegal because they have jurisdiction, Lord. Ex parte illegal order was passed illegal, Lord. Therefore, it has to be passed and direct the head governor of affiliate court, fixing a hearing for the appeal by giving equal opportunity to both the parties and hear the appeal and pass the decision. That's all, Your Honor.
So, according to him, he don't want this matter to be remanded back to the appellate court.
No, Lord, because my appeal, I have filed before appropriate forum. As per Arunachal Pradesh Civil Court.
We'll say appropriate forum.
Yes, Lord, of course, their jurisdiction has been convinced by my Lord.
My lord, why I'm not wishing to go back to the Kaba because they are totally in favor of him. And one more
Cannot do.
one more clarification is, my lord. In Parwana, 3 new member has been added, but in the records they were not present in the meeting, not reflected
That
as
is why I am not onto the merit.
lots of things are there where they are.
He's clear.
Yeah.
Otherwise, to
Not on the
remand it
merit
back to the back to
No,
the
Your Honor,
appellate
as per section 24, let them approach civil court.
Then what about my appeal, Lordship?
That has
filed before appropriate forum.
that has been already decision taken. That is going to be set aside.
Then
So
this
let them-
should be upheld, Lordship.
let them approach the appropriate forum. Just that.
Let them file second appeal, Lordship. Then may I humbly pray that, Lordship, if they are not challenging the ex parte, then
I'm challenging ex parte. That's why I'm.
then what is the remedy, Lordship?
Remedy is appropriate for. Let them approach appropriate forum. Appropriate is covered there.
Territorial court is not the appropriate.
address,
It is there.
address the court.
Lordship.
Yeah, just not remanding. Just allow them to approach appropriate forum. That
This
much.
matter, Lordship,
Okay.
has been
Well-
dragging since last 3 days, Lordship.
Okay.
3 hearings.
There must be something. That's why Lordship has dragged this.
Because
Or
of
else-
the inconsistent placement of the
hearing
fact,
had-
Lordship.
And the query raised by the petitioner was to be clarified, and today it is has been
Yes,
clarified.
Lord.
Okay, so I'll pass order then.
Yes, Lordship.
Okay.
Lordship, appropriate forum will cover both. There and mine.
It will amount to dismiss my appeal, Lordship, because I have already filed appeal before the appropriate forum. Now, the aggrieved party will choose the forum, whether I should go to the territorial court and I'll approach the civil court. It is my decision because I'm a Christian.
Mr.
That's all.
M. Edwin, planning counsel for the petitioner. I've also heard Mr. K. Lawley, planning counsel for the respondent. Okay.
Obliged.
Then, the hearing concluded. Okay, judgment reserved. Okay. Order
Obliged.
reserved. Huh? The doubt raised by the petitioner has also to be clarified, yeah. Okay.
Item number 6, password for the typing matter.
Mayor Lordship. Lordship, this is
item.
Lordship, this petition, civil revision petition under Article 227 to set aside and quash the impugned judgment dated 07/02/2025 arising out of impugned order dated 15/05/2023 being passed by this Civil Judge Senior Division Upper Subansiri Dapur region. So, to be precise, Lordship, the brief background of the case is that if Lordship turned the page number 54, where the original first Kebang decision was passed, page number 54, 54. So it's before the coming up of this 2021 Arunachal Pradesh Civil Court Act. So here, then there was one Kebang, and Kebang was held, and after Kebang, then there is a practice over there in village authority. They give report to the concerned jurisdiction officer before the amendment of 1945 regulation. Since then, before that, section 38 was not deleted of 1945 regulation. Therefore, the matter was taken up by Gaungura.
Page
54, 54.
What is that?
It's a Kebang report decision where originally the case was determined in the village level, and report has been submitted to the subdivisional officer Nacho by the Gaungura, that head Gaungura. That's
Who lodged initial complaint?
initial complaint is being lodged by me only. That
Okay.
the instant this petitioner in this CRP.
Okay, then mail order was passed.
Yes, and subsequently after this, it's very simple, Lordship. Where means my land has been sold by one of my distant clan brother without my knowledge, and that has been come later on once there is a developmental activities erop up. So later on, based on this customary judgment, it has been brought to the record of that office that that person cannot sell my land to someone else. But subsequently, that person, the person who represented other party, they pleaded that, okay, then you return the money. And subsequently, as per the Kebang decision, they agreed that, okay, we will return that 50,000. That was the actual amount. Originally, that pecuniary amount was only 200 rupees. So this is the original one, first customary
100
judgment.
rupees, in which year?
In 1970, 78.
Okay.
And later on in 2019, after determining this case, then it was, they settled as per the Gaungura. They finalized, okay, this person has sold this land to you. Then you paid this 50,000 in lieu of that 200 rupees. So that was the judgment according to the village level. And subsequently, after
Which judgment?
this page 54, where means Gaungura and PI.
This is report.
Yes, report.
Just a minute. Let us see. Let us read this order. This is not order, it's a report.
Yes, Lordship. There are 3% lordship.
3%.
Yes, 3%. One is,
You are for?
I'm for, this Tararava.
Is
And
the
yes,
petitioner here.
yes,
So
petitioner in
what
this.
was the decision in the page 54? It's against you? It
No,
was
it's in my favor.
in your favor.
Yes.
The money was to be paid to you.
No, actually land original belongs to me, my father's land. And my
Okay, you have
distance,
to pay back rupees 50,000.
not me, my brother, one of my distance brother, this Tariq Rava, his father has sold that land to this, the respondent,
Land actually belongs to?
belong to me.
Okay, but his father sold
Yes,
it for 200 rupees.
yes. So,
Now Keba decided that he should return 200 rupees and you should return the land.
yes. But land was in my possession only, Lordship. But there was some developmental activities, road cutting. PMGS road cutting was initiated. And this respondent, he being an influential person, he brought that project. So in village, what happened, whenever there is some road project or any type of work, then usually landowner, they create hindrance. But for the greater interest, from their inside, there is my, my area is there, my lane is there inside also. So thereby means, I thought, okay, let it be continue. But later on, what happened, this person started claiming that their father, respondent's father, has bought that land from one of my 7 generation distance brothers' family. Then in that regard, their family has been summoned before this customary court by the Gaumbra. And during this Kevang, what happened, then it was clear enough that I'm the owner, original owner. But meanwhile, this person is cutting the road. And that person whose father has sold, they are bound to pay this amount. Since that person,
What is the name of the, he is a respondent?
respondent is
Who sold respondent? Who sold?
Tariq Rava, late Tariq
Rava is
Rava.
not the party here.
No. In title suit also, he is not party. So that's the man, after this decision, now here, one is Tariq Rava, one is Tara Rava. Tara Rava is the petitioner in this instant CRP.
Tariq Rava sold.
Yes, Tariq Rava is the father of one of the representative over here.
Whose father?
Uh,
There is only one respondent.
Kandu Rava.
There is only one respondent here. Talok Bialing.
Yes.
Where is that? Where is this Tariq Rava
Now, Lordship, that's why.
and his son?
That's why. Here, as per this Kebang decision, land was sold by one person, Tariq Rava. And his son appeared on behalf of his father, late father. His name is Kandu Rava.
Tariq Rava sold to whom?
Sold to Taluk Bialing.
Talok Bialing is
Taluk Bialing's father. Taluk Bialing.
Tariq Rava is still alive.
No, his son is there. Name is reflected there in this page number 54 only. In this
Tariq Rava is father of
Kandu Rava.
Kandu Rava is not a party.
Actually, he is not party in this civil revision petition. Since I'm challenging the judgment being passed by the civil judge senior division, Daporoja, where means Kandu Rava and Tariq Rava, they are not party. So this is the background. And next page 55, it's a report by this subdivisional officer, means land dispute case, where before the coming of this 2021
Just a
APC.
minute. Khandu Raba's father, Tariq Raba, sold your land.
Yes, Lordship.
Your land or your father's land?
My father's land.
Okay. Oh. Okay, just one sentence, one sentence. Huh? One Sri Tariq Raba, father of Khandu Raba, within bracket, who is not party to the case, bracket close, sold petitioner's father, sold the land belong to petitioner's father to the father of the respondent, Taluk Bialing.
Yes, yes, Lordship.
Or none of the parties are present. No. So then,
After this, based on this report, the subdivisional officer,
okay, you are the complainant.
yes, initially, in the initial, and in page
Where
number,
is your complaint?
to be honest, Lordship, then in 2019, in village level, there usually happen to be a verbal complaint, and subsequently it's need to be endorsed by the concerned magistrate. Since magistrate were given power by 1945 regulation under section 38 to issue order for the arbitration. Based on that, usually Gaongbura, they settle the case for arbitration as an arbitrator. So then, as per that, I don't have any exact written record, complaint record, but based on the order of this, subsequently, based on that only, there is in page number 55, there is a land dispute case between this Tara Rava and Taluk Bialing. There is one order being passed by subdivisional officer Nacho. Next page, it's there in page number 55. And next number G.
Yes. What is this?
This is a,
This is case.
yes, where means,
Is this a decision or what?
then I will not appreciate these things, but then in most of the village area, after the report being submitted by the Gaongbura, usually those verbal decision has been brought into in written form by the concerned magistrate only, especially in rural area. So this is from this Dapur Jo Nacho, where means subdivision officer has recorded that things and that has been brought on record. So in this order, it's clear that as per this order, may I read this order?
This order was passed based on the report.
Yes, based on the report.
Okay. Okay, yes.
Where means, as per this order, it was clear enough that, okay, someone has Mr. Tariq Rava, son, means Mr. Tariq Rava has sold that land to the father of Mr. Tade Bialing, Taluk Bialing. That's Tade Bialing. So therefore, yes.
Where are you reading?
So it's there in paragraph number, third paragraph. The Kebang has come to the conclusion that the land belongs to Sri Tararava. That's me. Son of late Taurava.
Tararava.
Yes. And Sri Tarik Rava wrongly gave the land to Sri Tade Byaling. That's area name is, land name is Kyojariang, village for cultivation, without the knowledge of Sri Tararava. Now, Sri Kandu Rava, the son of this Tarik Rava, who has sold that land, now the son of that Tarik Rava, now Sri Kandu Rava, son of Tarik Rava, has agreed the Kebang decision and admit that his father unknowingly allowed Sri Tade Byaling to cultivate the land which was wrong decision. Now he agreed to return rupees 50,000 and deposit the money to the Nacho local Kebang to pay Sri Taluk Byaling, the instant respondent. And Sri Taluk Byaling will withdraw his claim over the land as decided by the Kebang, wherein it was already decided. The Kebang decision is upheld and Sri Taluk Byaling is directed to obey the Kebang decision. The aggrieved party, Sri Taluk Byaling, may appeal to the higher authority against the Kebang verdict and this order. From this only the Taluk Byaling, after around 253 days, means after 253 days, file appeal before the additional district Judge Basar.
Which one?
Now, that's in that's annexed there in page number 56, Lordship. The memorandum of
This is appeal.
Yes, memorandum of appeal. They file appeal challenging this order.
Challenging the order of the, this is
Subdivision-
ADC.
Yes, ADC and this Gaungra report. Which they presume this
Filed
judgment.
before whom? Appeal is filed before?
Initially, they filed before this additional district Judge Basar,
Hmm.
page number 56.
This
Lordship.
is a FTC.
Page number, Lordship, 56, 56.
It is additional district judge is FTC, first track court.
No, Lordship. As per the Civil Court Act 2021, Section 15, Clause 3.
Okay, it's only 22. This is when? The order was passed way back
2019.
19, okay. So this was, okay.
And
After,
yes, after this,
after the act.
after filing this appeal, later on, this appeal has been later on after being intervention of this honorable court. That order is not with me. Then it has been re-endorsed back to the Civil Judge Senior Division Daporijo.
Who?
By this, it's if Lordship see the page number 67. Page number
So
60.
this appeal, just a minute.
Yes.
What happened to this appeal?
So that's why this appeal has never been heard. So it has been reversed back to the Civil Judge Senior Division Daporijo
By?
by additional District Judge Leparada, that's Basar.
Order was passed in this appeal.
Yes. So based on this,
Where is that order?
Lordship, actually I have not annexed, but subsequent from this, if you see Lordship, it's page number 67. Here is a order dated 14/03/2023, where means as per this order, a record can be seen easily. That case records put up on receipt from the Honorable Additional District and Sessions Court, Basar, Leparada District, with order dated 02/03/2023, passed in Basar IA 116 22 in Basar, Civil Appeal 1322. Same is re-registered as Daporijo Civil Appeal number 02/2023.
Where is this 2/3/2023 order? 2/3/2023 passed by additional district and sessions judge.
Yeah.
Basar.
Lordship, there is no order. Just file has been returned back to this civil judge senior
There
division
might be some
Dapor.
order, forwarding or whatever maybe, but then there has to be some order.
Yes,
Has to
Lordship.
have some order.
Yes, that's why.
Based on which it has been
Now, that's why.
transferred.
That's why. That's the reason I'm before this honorable court. Reason is that.
Okay,
after-
there is no order. That's why you have come.
Yes, that's a one record, because still I could not get that record, Lordship. So,
You want this court to give you that?
no,
record.
no, I'm still into that. Now, Lordship, now after this order, subsequent next page, Lordship, page number 68. If we read this order, then subsequent order, then it will be very crystal clear.
What is that?
As appellant is present with learn this, respondent is represented by learn counsel this. The instant appeal is transferred from the court of additional district judge, Basar, for disposal. Learn counsel for the appellant submits that he has filed an application with number 1622 for condonation of delay. This is only for the condonation of delay, Lordship, of 242 days in filing the instant appeal before the additional district judge Basar, but same has not yet been heard yet. It has further submitted that respondent has already filed his reply against the said condonation delay application. In view of the above, let the matter be fixed for hearing application number 16 on 15/05. And 15/05 order is there in page number 50, Lordship. Page number 50. Now, page number 50, Annexer E, Lordship. Order dated 15/05/2023.
What is this? This is order passed by civil judge.
Yes,
Is this impugn order? No.
this is one of the impugn order. Arising out of this, learned civil judge senior division Daporijo has tried the case without any fresh title suit. Just hearing, considering only the delay condonation and considering the memorandum of understanding as a title suit. So may I read, Lordship?
The order dated 15/5.
Yes.
Please.
So case is listed today for hearing on application number 1622 filed by applicant under section 5 of Limitation Act. This is only for condonation application. For condoning the delay of 240 days in filing the appeal. Applicant is present with learned counsel RT. This opposite party respondent is represented. The case of the appellant is that he inherited a plot of land from his father, which was purchased from Tariq Rava. They are not denying they had purchased the land. That after 41 years, that's in the year 2019, respondent Tara Rava, the cousin of Tariq Rava, Rava started claiming the land. And as a result, a kebang was held on 15/10/2019. A report of the same was sent to SDO Nacho. On receipt of the report, SDO Nacho has passed an order dated 26/11/2019, declaring the ownership of the land in the name of respondent Tara Rava. Being aggrieved by the said order, applicant has filed an appeal before Deputy Commissioner Upper Subansiri in the month of December 2019. However, the same was returned to the applicant on 17th December 2019, saying that the proper authority to hear the appeal was ADC Kodako. Accordingly, applicant has filed appeal before ADC Kodako on 25th December 2019. As his appeal was not heard, and in the meantime, Arunachal Pradesh Civil Code Act 2022 also came into force. So the file was returned to him. Consequently, he had filed an appeal before the additional district judge, Basar, but the same has been remanded to civil judge, senior division, Daporijo, as the property in the dispute is situated within the jurisdiction of the said court. In support of his claim, applicant has enclosed the report submitted to SDO Nacho by the village authority, order of SDO Nacho dated 26/11/2019, order dated 17/12/2019 of the Youth Deputy Commissioner Upper Subansiri directing the applicant to file appeal petition before the ADC Kodako, and later dated 01/06/2022 by the ADC Kodako, returning the case filed to the applicant. Learned counsel for the applicant submits that the limitation for preparing appeal against the judgment of the customary court is 30 days. In the present case, SDO Nacho passed the impugn order on 26/11/2019, and hence the limitation period expired on 26/12/2019, and the instant appeal petition was filed before the Additional District Judge Basar on 04/06/2022. But that same was dismissed on the ground that Honorable Additional District Judge Basar has no jurisdiction to take up appeal pending before ADC Kodako against the order of the Honorable Additional District Judge Basar. Applicant has filed an appeal before the Guwahati High Court, Itanagar bench, which was allowed. Accordingly, applicant had filed a fresh appeal petition before the Honorable Additional District Judge Basar on 10/08/2022. After going through the appeal petition, on District and Session Judge, District Judge Basar has transferred the case to this court for trial and disposal. The learned counsel submits that delay of 242 days is counted from 26/12/2019 to 09/08/2022, the day before when the appeal was preferred before Honorable Additional District Judge Basar for the second time. Hence, the counsel for the applicant has prayed for condoning the delay of 242 days in filing the instant appeal, saying that delay was not deliberation, but the appeal filed by the applicant was kept pending by the ADC Kodako without the disposal. In the contrary, learned counsel for the opposite party, respondent, contends that no appeal was filed before ADC Kodako. He further contended that there is no mention of the appeal number and date of the appeal filed by the applicant ADC Kodako in the acknowledgement issued by ADC Kodako. And the appeal was filed on 25/12/2019, which is not believable as 25th December is Christmas day, and all the government officials are remain closed on the said date. The learned counsel for the respondent contended that if the appeal was really filed, then there should have been appeal number, as while filing the appeal, it is required to be registered, but no such document has been furnished by the applicant. Hence, he has prayed for dismissal of the instant application. I have gone through the replication filed by the applicant against the objection reply filed by the respondent, wherein applicant had enclosed acknowledgement later dated 31/01/2023 issued by ADC Kodako, along with copy of appeal petition filed ADC Kodako. On peruse of the aforesaid acknowledgement letter, it is found that the appeal number is not given and same has been stated to be filed on 25th.
Okay, learned counsel, you have challenged which order?
I have challenged this instant order, which
Okay,
I was
what we'll
reading.
do is,
Here.
you have any objection admitting for hearing?
Otherwise, it's a small matter. It can be
See, again, over and again, we'll have to hear all, both of.
It's subject to your lordship convenience. In fact, I was also going to pray for disposal. Because these facts as such are not much disputed.
Mhm.
I'm on the issue of law, whether this CRPK is also can be filed in this manner.
Which one is impugn order?
Means,
This is
impugn order is page number 24. That's a judgment.
This was not an impugn order.
That's
Page
it.
24.
But the order which I was reading,
Hmm.
arising out of that only this impugn order has come up.
See, and then this, and probably impugn order is also very long.
No, that's why lordship. It's very simple.
Hmm.
It's very simple. Is that first is there as by a learned counsel has,
This order is basically disposing of the condonation petition.
yes, at
The
without
delay was condoned by this
yes
order.
yes,
Okay.
but without
Make it
any
simple. Hmm?
without
Without-
any fresh petition and without any fresh title suit, how this judgment can come?
But judgment was passed without any petition. No,
Yes.
there was no petition.
Yes, just they consider this appeal. There is a difference in between memorandum of appeal and fresh suit. So after, as per the AP Civil Court, after admitting the condonation and admitting the petition, considering the facts and circumstances by
No,
quashing
the
that order,
petition must have, see, this condonation petition
yes,
for what? Filing appeal only.
yes,
It says that for filing appeal,
yes,
condoning the delay of 242 days in
Yes.
filing the connected appeal
Yes.
only. So according to you, there was no appeal.
there was appeal. That's why
Okay.
there was appeal.
Hmm.
And appeal was considered. And after considering the appeal,
Hmm.
then the learned civil judge senior division need to pass that order by stating that after considering, now case will be tried in de novo. In that regard, the previous customary judgment will be quashed, but there is need of fresh suit. So thereby it means if we read the order 7, rule 1, Roman I, means I, close I. So apart from that, if we read also AP Civil Code section 14 also, pecuniary jurisdiction. There is a civil court junior division where means below 10 lakhs matter need to be taken up by the civil judge junior division. Whereas this is civil judge senior division.
But a junior division is also there
Yes, Lordship.
at that time
Yes,
at Daporizio.
yes. So
So according to it should have been endorsed to the civil judge junior division
yes, yes,
as
Lord.
per the pecuniary jurisdiction of the.
Yes,
Okay.
if we read order 7, rule 10 A and B,
It was not
After
endorsed.
examining
It
the-
was not endorsed.
yes, it was not endorsed. Then this concerned court has tried just considering the appeal only and passed judgment also. So that's the reason means there is a miscarriage of even for jurisdiction also.
Appeal is to be filed before whom?
Appeal is to be filed if suppose that's below 10 lakhs as per the AP Civil Code section 14 to be filed before the civil judge junior division only.
Appeal from the
Village author customary court.
customary court.
Yes.
It has to be civil judge junior division.
Yes, if as
But
per
here is the case where senior division has taken
yes,
up.
yes.
So you have that. You have that grievance.
That's also grievance. And apart from that, even as
So
per the report,
that means the civil judge senior division doesn't have a jurisdiction.
yes,
Or
Lordship.
okay.
And
So that is one. And the other one is
other one is that there is no plant, there is no any suit.
no, it is appeal.
That's why how learned court can consider appeal.
There was no appeal memo.
No, there is appeal memo,
Then
but that appeal memo cannot be treated as a plant. There is need of fresh plant.
of the appeal only.
Yeah, after disposal of appeal, in appeal, usually they review, as per my understanding, they review the customary judgment. And if judgment is impugned, then it need to be quashed or set aside. And after that, fresh title sheet should need to be filed. And there will be fresh contest of the case. That's
Was it a de novo trial?
yes. In that, which I was reading 1505/2023, where means they had
So many things I think it appears
Yes.
mixed up.
My lord, I will just clarify just fact.
Uh-huh.
The facts remains that there was a kabang, my lord, and against that kabang, the respondent herein, my lord,
Hmm.
he preferred an appeal before the DC, man, at that time, before the Civil Courts Act, man. Now, of course, your lordship also knows, my lord, DCs, they usually don't take up this matter due to various reasons.
Can't.
It was never taken up. In the meantime, this Civil Courts Act 21 came into force.
Okay.
And after that force came into force, my lord, that our appeal against the order of the Kabang was returned back to me, ma'am, saying that you file before appropriate forum. Now I approached the additional district judge Basara, but the district judge Basara said I do not have the jurisdiction to take up the appeal that was pending before the DC, and he dismissed it.
Deputy Commissioner, without transferring it or endorsing it to the civil judge,
My lord.
just return it
Yes, return.
back to you.
Yes, ma'am.
No order was passed.
No, ma'am. It is just returned, my lord. And after,
It was locally returned to you.
yes.
Okay.
Now, after that, no, some order was there, man. It has been mentioned in that order of the condonation of delay also. These are facts, my lord, now gone by, man.
Okay.
Against the order of the district judge, my lord, additional district judge, I approached this honorable court. Honorable court says, you have the jurisdiction, you try it.
To whom?
Additional. Now, in the meantime, what happened that 21 Act, my lord, Civil Courts Act, it was amended. Earlier, from the district customary court, appeal would lie only to the district judge. Now, in the meantime,
As per the pecuniary.
yes,
And
yes, the civil judge junior division and civil judge senior division were also included in the 2022 amendment.
Mhm.
Now, when that amendment came into force, and after the direction of this honorable court, my lord, the district judge transferred it to civil judge senior division, Dapurijam.
Okay, as per the jurisdiction.
Yes, jurisdiction. Now, when that but still the matter regarding the delay was pending. Now, when the appeal for condonation of delay was taken up, the court considered the facts, all the facts, and observed that there was no delay in laches on the part of the appellant, the respondent hearing, and accordingly condoned the delay, and in the same order directed for de novo trial. That was in 2023, madam.
In the delay condonation petition.
Yes, ma'am. That was done, ma'am. After that, in the 2023, my lord, the respondents, the petitioner hearing, they were the defendants, my lord, there. They also appeared entrance, my lord. They filed their written statement. The trial commenced, and after the decree has been passed, judgment and decree has been passed, this CRP has been
Okay,
filed.
they did not raise any objection before that.
No, nothing, never. And they did not, although they have put to challenge, impugned the order also of 2023, 15/5/2020. At that time, it was not put to challenge, man. And by that act also, the limitation was it's beyond limitation to put the challenge, the order of the 2023.
Now, see, the additional session judge, session court, Basa endorses to the apology CJM.
My lord.
If the pecuniary jurisdiction falls under the judicial magistrate's first class, or sorry, the civil judge junior division,
Ma'am.
was it not the duty of the civil judge senior division to endorse it to the junior division?
No, my lord, pecuniary jurisdiction, that is the only the petitioner is saying so that it should lie before the deputy commissioner, junior division, my lord. And this
Junior division or senior division?
I'm saying it will lie before the senior division, my lord. This is disputed fact,
No,
which
no,
cannot
but
be
I was saying
decided, my lord.
Junior or it should be before the junior or senior.
I'm saying before the senior division.
Okay.
My
So you
brother
said
here
that
is saying
senior
that it should be before junior division.
Hmm.
But the fact remains,
Hmm.
they participated in the trial,
What is the limit of the junior division?
10 lakhs, man.
10 lakh. And here,
My lord,
Yeah.
the property as such, I'm saying it is more than 10 lakhs. It's a land, man. Now he's relying on the fact that some judgment was given for regarding that 50,000 should be given back, man. On that ground, he's saying that the cost of the suit is 50,000. That is not the case. But
Okay.
otherwise
So
also,
on on that basis, he's saying that suit value is 50,000.
50,000, yes.
Whereas it was only fine.
Fine.
The value is more than that.
Yes, land.
Where do we find the value of the suit land?
Value of the suit land, my lord. Value of the suit land, my lord, is not decided as such, man. But I'm saying, my lord, because that's why I'm also coming to, my lord. This is a disputed fact, my lord. What is the amount? What is the cost of it? That cannot be decided by this honorable court under supervision, my lord. And Otherwise, in CPC, under the CPC, section 21, subsection 2, there is a specific bar, my lord. Appellate and the revision court cannot take up this issue. If the parties and if the person who is agreed by that doesn't raise the issue of the pecuniary and territorial jurisdiction in the first instance, my. Now everything has been decided and the title has been decided in my favor, and same is not palatable to the petitioner herein, my lord. He has come in revision, my lord. And otherwise the appeal lies, my lord. And when there is appeal under the CPC also, that is also a bar also, my lord, in exercising the supervisory.
Impugn order is disposed by impugn order, whether it has disposed of the appeal or what.
No,
It was tried de novo.
that's why,
Then it,
Lordship, that's why.
okay,
Before trying de novo,
you have come by way of filing this revision,
yes,
not the appeal.
no, not appeal. Appeal, that's other way. Now here, Lordship. First thing is that whatever my
On jurisdiction.
what he's saying, main question is that to try a case de novo, there is need to establish a pecuniary jurisdiction first, right? Main thing. Here, without any plan, that's why that issue is there. If we see order 4 also, where means order 4, it's very clearly stated as per the CPC, pecuniary jurisdiction need to be established first. Then only that matter can be taken into cognizance. Without that, there is lapse of procedural error in this case. So that's the reason it has brought under this revision only, supervisory jurisdiction. Because if this practice continues, then
I think it needs further consideration, it appears.
yes, because law is very clear, Lordship. Section 14 of AP, if you see, Lordship, my petition page 20, I annex that AP Civil Code. Section 14, it's very clear about the jurisdiction of Court of Civil Judge Junior Division. It's crystal clear.
We'll have it hearing
My lord,
by 58.
yes, what was my lord, it will remain in for admission hearing, my lord, after the vacation, my.
Okay. Both the land council for the petitioner, Mr. P. Kipa, and Mr. Julius of the land council for the respondent are present on the request of both the land council for the parties. Let this matter be listed after the ensuing vacation, ensuing puja vacation. Okay,
Lordship, date, fixed date.
fix that.
October
Okay, let this matter be listed
7,
on when?
October
27,
27, my lord.
Okay.
For admission hearing, my lord.
Okay.
Of late.
Item number 25 and 26.
Earlier.
Meet the lordship.
25 and 26. Okay, this is good. Yes,
I know my only one matter that is for my lord, my prayer is regarding my lord, re-verification of the area, my lord. It is filed under
all
226 of
parties are
Constitution.
present.
For the NHPC, my lord, I don't know for the government who appears.
4 and 6. Who is for 5? You have correspondent number, correspondent number.
My lord, we appear for the respondent number. Who has done all this? Respondent 5, yes.
You are for 5.
And
5 was to file any affidavit.
yes,
you
we
know,
have
but-
filed affidavit as well as the additional affidavit.
You have
as per the
filed.
Order of this honorable court.
You have filed.
Yes.
You have
The
received the
pleadings
copy?
are complete.
Yes,
The pleadings are complete in
Yes.
this case,
Okay.
subject to the government, whether the government has filed any affidavit or not.
Yes, yes.
Just a minute. 3 also filed.
I'm sorry, my lord, then in that very case, government, whether, have we got the copy?
We have for
I
5.
would like to, the affidavit of the government. Kamal? Huh? My lord, because the stand of the government is very important for us, we would like to know what stand government has taken.
Earlier you made a prayer for filing rejoinder to the affidavit in opposition filed by the respondent number 5.
That they
Yes,
have
yes.
done, they have done it,
Done it.
They have
They have
you
done it.
filed.
they have
Okay.
done it. But my lord, I would like to have the copy of the government because. stand of the
Government has
government
filed.
is
When
important.
you have received the
No.
affidavit filed by the government,
No, no, my lord, we have not,
land council for the petitioner have received the copy.
Yes, sir.
Okay.
my lord, but
Government has
this
to serve the
respondent
copy.
will have to pay, respondent 5 will have to, ultimately, my lord, we are going to be prejudiced by any order of re-verification or resurvey. Therefore, the
Please
stand of
complete my
government-
submission, my lord.
Please,
Please, my lord.
please,
Uh,
let me complete
Just
my
a
say.
minute. Just a minute.
I have started my,
Let me
we-
complete my say.
Not yet started. Not yet started. Waiting.
So, my lord, we would like to have the affidavit of the government to know its stand.
Okay.
Because whatever happens after the resurvey or the re-verification, subject to the order of the honorable court, it is the NSPC which will be prejudiced, and it is we who are objecting to their prayers.
Okay. So,
Lordship,
serve a copy.
okay, your lordship, the petitioner has not served rejoinder, your lordship.
Rejoinder also, you serve a copy, furnish a copy of your rejoinder to the land.
what kind of song?
Council.
I have already submitted the affidavit in opposition or reply.
Have you served the copy?
Yes.
It is in the
Not
court.
served, your
Huh?
lordship.
Probably you have to serve copy, and then the government also need to serve copy to
Yes, your
the,
lordship. Please serve,
Oh.
your lordship. After this.
after
Today, your lordship.
today. Then
My lord, today
They
if
have
we
a-
get the copy, then my lord, one thing is certain, nothing is going to happen before the vacation. It's not possible because tomorrow I'm leaving for Delhi. My mother has been hospitalized.
oh,
I have to leave for Delhi tomorrow. So that's
Then,
my
My lord, the
problem.
copy of the
serve the
government affidavit is along with me. I have, it's annexed in the, my affidavit in reply.
okay.
My learned advocate, senior can use it. Yes.
Only three things. Where is it?
Annexed B. Annex
Mr.
B.
These are the photocopies of the assessment of the property. Pleadings are not there. Where are the pleadings?
Heard Mr.
Only
Tison,
photocopy.
land council for the applicant. This is, we are on. This is IA. Okay. Also, Mr. So you have received all the copies?
Yes, ma'am.
Okay. Miss Pangu is for
It's point number 1, 2, and 3, your lordship.
1, 2, and 3. Pangu for respondent 1, 2, and 3. Who submits that she has not received, not yet received a copy of rejoinder filed by the council, filed by the petitioner. Mr. Son, Land Council for the petitioner shall furnish a copy of rejoinder filed by the petitioner to Ms. Pangu within 2 days from today. Okay,
I have to check it because it was already filed, my lord.
okay. But check it if they have received. You also check? Okay. Mr. Also heard Mr.
Yes.
Tiwari, huh? Land Senior Council appearing on behalf of Mr. Tiwari, you appear, Land Senior Council appear, assisted by.
Kamal
appear,
Saxena.
okay,
Kamal
Saxena.
Saxena.
For respondent number 5, who submits that he is yet to receive an affidavit, receive a copy of the affidavit filed by the respondent number, the government respondent number 1, 2, and 3.
What was?
Ms. Pangu, Lani Government Advocate, shall furnish a copy of the affidavit in opposition filed by the respondent number 1, 2, and 3 to the Lani Council appearing on behalf of the respondent number 5 within during the course of the day. Stop. Huh? It's therefore by the Lani Council for the parties. So this
My lord, till 21st, I understand there are vacation over here. 27th, my lord, I am here.
27.
Yes.
27 some other matters, I think
28th.
28 can be.
Yes, 20.
Okay.
28th.
My lord, this is a very easy matter. This similar cases
but
have
they have
already
not-
disposed of, my lord.
Yes, they have not.
My learned friend, he is raising the objection.
One by one.
My lord, this honor court has already decided the matter, my lord.
Okay, but
Yes,
then
Lord.
they have not
Yes.
received the copy. Let them receive the copy. We'll decide in the same way if it is a similar matter.
Division bench judgment is against my learned friend.
Okay. Okay, as agreed upon by the parties, let this matter be listed on 28th October. Okay,
Amar Patel.
28. Okay, what is this?
28th. All right, but can we have the which judgment?
Yeah,
This is
Yeah,
not
no,
division bench,
present.
single bench.
single one.
My lord, whose judgment is this? Just for my.
R. Pokon. Ravin.
Ravin.
Pokon.
My lord, may I, because I remember this very judgment has been, my lord, already set aside by the division bench. If
Okay,
This is the judgment
6,
of Robin
6,
Pokon.
2025.
Yes, yes.
Okay.
Set aside by division bench.
Okay, so probably that also may be
Yes.
required. Okay.
If this is Robin Pokon's judgment.
Field survey comprising of a responsible officer for the.
Yes,
concerned
exactly, my
department.
same subject matter with me.
That's why the division bench judgment is against me.
That order also may be required next. Okay. 28.
All right.
Item number 27.
Item number 7. 16. Item number 7. Item number 6. 15. 27. Okay. Yes, item 27.
Lordship, in this item, I am the informant appearing in person.
Now, this was to be listed before the appropriate bench.
Lordship,
Yes, but why it has been listed again here? Because the
Lordship, I am
similar
also,
matter was disposed of by Justice A.M.
it should
Kalita.
have been before Justice Thakuria, Lordship.
Is it?
No.
Lordship.
No, the A.M. Kalita, Justice A.M. Kalita. I don't know, but there is office note also, but why it has been listed again? Yes. Just a minute, huh? April 9. Just a minute, huh? There is some notification. Wait. Okay, so there is a notification, recent notification letter. It has to be listed either before the Anjanmani, Justice Anjanmani Korita, or before the, as per the roster at Itanagar. So that means it can be listed before this court also.
Yes, normally, Your Lordship, there was a notification saying,
Yes,
stating that,
after that only, because on the, based on this, that notification, we have passed order.
yes,
Okay,
because
but then now this notification, you can just see. This is with regards to the interim anticipatory bail granted to the accused. So if the bail has been rejected,
no, there is,
Granted.
there was another case with regard to the same FIR.
no, now this has been clarified by the chief. It was proposed and then now clarified, either it can be listed before the same justice, same court or same bench, or by as per the roster.
If I may just read, Your Lordship, because
Yes.
there is a reference, I'll just clarify to that effect, Your Lordship.
Uh-huh.
Though the interim was granted by Justice N. Kalita, Your Lordship, there, an bail arising out of the same FIR was rejected by the same, different bench, Your Lordship. Now, when I speak of this,
Rejected by different bench. That
different,
was probably not brought into the notice of this,
honorable court, Your Lordship, because I'll just point out, Your Lordship,
because it was actually duty of the register
to get
who deal with that. It was rejected, not interim.
this,
By this order, only interim.
this order only speak of the interim that was granted by Justice N. Kalita, Your Lordship. However, there was an FIR arising, there was a bail arising of the same FIR, Your Lordship, which was granted by another bench, Your Lordship. This matter ought to have been placed before that bench, Your Lordship.
Rejected.
It was allowed, Your Lordship.
Lordship rejected.
Rejected, I did.
Rejected.
Rejected by,
Then in the case of
Because-
rejection, it has to go to the same bench.
Same bench.
So
Yeah.
probably this registry, while forwarding the order passed by this court for placing it before the appropriate bench, probably that was not brought into
Yes,
notice of
this,
the honorable
the
chief.
joint register has put the stress only upon the
Yes.
judge who has granted
Interim.
the interim. That is
Interim,
not the case
interim
here, Your
is,
Lordship.
is clear with regards to interim, because on that day also, I remember we were talking about the interim, and
Yes.
it was a rejection only. And
Yes.
that is why I have also passed
Yes.
this order.
However, since the petition also does not speak about that, that case, Your Lordship,
Uh,
that bail application arising out of the same FIR, therefore the registry might have missed that particular point, Your
So
Lordship.
what do we do now?
Otherwise, the notification clearly speaks that if the bail rejected or
Rejected by,
by
Hmm.
any of the bench,
Hmm.
the any of the bail petition arising of the same FIR shall be put up before the,
and probably the registry need to be asked about it.
yes,
So, because he actually was supposed to
Hmm.
refer that rejection order only.
yes.
Not
Notification
the interim.
27, serial number 3 clearly speaks about that.
Mhm.
Your Lordship, otherwise also if, because I'm not in position to give Your Lordship the case number in which the earlier bail application was rejected. If Your Lordship, just give me 1 minute.
So who is the
Your Lordship,
petitioner? The counsel said?
the main accused,
No, who appeared for that? In the same counsel? Did you appear?
Lordship, may I kindly assist my Lordship in the matter, Lordship?
Yes.
Lordship, in both the petitions, the same counsel appears and they deliberately suppress this fact before this honorable court.
You are
The
who?
earlier,
You are who?
I am the informant of the FIR, Lordship.
Okay, informant only. The petitioner is not present here.
No. And Lordship, I will just like to place my humble submission. Earlier anticipatory bail petition 17 of 25 was rejected for suppression of fact. And I have placed that order before this honorable court through the court master. I think that order must have been placed, Lordship. AB 17 of 25, Lordship.
Questionable. Because this anticipatory bail should also not have been placed before Justice A. Kolita,
Yes.
A.M. Kolita, because earlier bail was rejected by whom?
Justice Thakur, Your Lordship.
Courier should have been placed.
And Lordship, the counsel is the same in both the petitions. And she deliberately suppressed this fact also.
Who is the counsel, by the way?
The one Nazneen.
See, this, then, in that case, this interim anticipatory bail was obtained by suppressing the fact that it was taken up by another judge, another bench.
Lordship.
Isn't it, Ms. Jenny? Ms. Jenny? The rejection order was passed by another bench,
Yes, Your Lordship.
coordinate bench,
It's AB 17 of 2025, Your Lordship.
Lordship.
17, that was rejected.
It was rejected on 11/3/2025, Your Lordship.
So that means the registry did not put up.
Because the same was not brought
Because-
even to, there was no reflection even in the petition, Your Lordship. My friend El Hagi had appeared on earlier matter, Your Lordship. And probably we had also not.
By
Your Lordship, I'll just, since it seems that they have given the copy of the order.
okay, none appears on behalf of the petitioner. Whereas Ms. Jimmy Lana additional PP for the state. And Mr.
Lordship, I am
Yeah,
Manish Agarwal, the informant.
Manish
Manish Kumar Agarwal, the informant in person, Lordship.
for informant. So, by an order dated 11/9/2025. This court directed for listing the matter before the appropriate bench. That is before Justice Mitali Thakuria, who by an order dated 11/3/2025 rejected the, this was what for the
Anticipatory.
rejected the pre-arrest bail, rejected the application filed by Manoj Kumar Bora
Bora is
in connection with filed by Manoj Kumar Bora seeking in seeking free arrest bail in connection with the Dormant PS case number 3, 2025, under section 120B, 420, 465, 468, 471, 193, stroke 34 IPC. However, it appears that the registrar has placed no, see, because it was why it had to be placed before Justice M. Colita when this was disposed of by, isn't it?
That's why my submission is that since there is no mentioning of the said AB
Okay.
in the petition, Your Lordship,
Mhm.
the court as well as from our even from our side, Your Lordship, we did not look into that.
Then in that
thing, Your
case,
Lordship.
the record reveals that the record reveals that by an order dated 11/3/2025, the Honorable Justice Mrs. Nikari Thakuria has rejected the anticipatory bail application. Bail application being number AB 17/2025 filed by one Mr. Manoj Kumar Bora seeking seeking free arrest bail, apprehending his arrest in connection with same PS case. Okay, ऊपर वाला अभी छोड़ेगा. However, the petitioner nowhere mentioned in the petition.
No, very much.
Okay. File AB 10 file the present petition AB number 107 AP 2025 seeking free arrest bail in connection with the same PS case number so and so same. Okay, without revealing that the earlier bail application filed in connection with the same PS case was rejected by the coordinate bench of Justice Apriya. Full लिखो, हाँ. Then by an order. And by an order dated 28/8/2025. The bench, the coordinate bench of Justice Anjan Manipalita granted free arrest bail to the present petitioner and by an order when this matter was brought before this court, by an order dated 11/9/2025, this court directed for briefing the matter before the appropriate bench. However, the registry, instead of listing before the appropriate bench, has forwarded the same before the Principal bench. The principal seat at Guwahati. Where is the letter? The registrar's letter is not there. Proposed to submit. The letter of the Guwahati is there, but then letter written by the registrar. Okay. Deputy Registrar Guwahati. Just a minute, huh? Deputy Registrar, Bank Guwahati High Court. Just a minute. Huh? Okay. Yeah. Where? You want to show?
Your Lordship is seeking for the joint registers.
The joint register of Itanagar bench.
Yes, Your Lordship.
Written to the register of the principal seat.
Communication, Your Lordship.
Yes. What it says in its communication.
There is a letter dated
That is
19.
Guwahati.
This is from Guwahati to Itanagar, Your Lordship.
No. I'm asking for the Itanagar to Guwahati.
Itanagar to
Because this is reply only. By this, they have
Yes.
allowed
Yes.
to take up the matter. But then what was this letter?
This is page number this.
By the register or joint register of Itanagar? See down below.
The Itanagar bench on 15th.
No, down below. Who
Yes.
has written?
Yes, no, there is another letter dated 15/9/2025 addressed to Joint Registrar Guwahati at Guwahati, Your Lordship. By the Guwahati High Court Itanagar bench, Your Lordship, where the
Subject?
scanned copy of the case record of AB
No.
was forwarded.
No. Then and then what letter? Writing requesting what?
In pursuance of notification number 27 dated so and so, it is pertinent to mention here that His Lordship has granted interim bail on so and so in aforesaid. Therefore, I am request to your good self to lay the same before the Lordship for listing the.
Joint register.
This is Deputy Registrar,
Deputy registrar while forwarding the case before the
Joint
principal bench.
Registrar Guwahati.
The case before the principal bench has referred only. Okay. Regarding the case record of AB 107 AP 2025. In which Honorable Justice M. Kalita passed an interim order on 3 May and 3 when it was passed. Okay. 28/8/2025. And based on the above letter, the registrar, joint registrar judicial place before the Honorable Chief Justice. With an option to be directed to, with an option to be to be directed to be listed before the single bench of Honorable Mr. Justice Anjan Manu Kalita, or that is A, and B, the above, or may be directed to be listed as per roster at the Itanagar Permanent Bench, or as your lordship may deem fit and proper. And in which the Honorable Chief Justice approve for listing, be approved for listing to be done as per roster. In view of the above, the registry shall do the needful. In view of the above, the registry shall do the needful. And if required, in view of the above, the registry shall do the needful. We'll say that only because the required is only, it has to be placed before.
Justice Thakurya's-
Justice Thakuria.
Your lordship can otherwise aid to the registry shall do the needful as per notification 27,
As per
serial number 3.
Where is that?
Uh,
As per notification, that is 3/5/2025.
Yes, your lordship.
Okay. In
Serial number,
accordance with,
serial number 3 is the
Hmm?
serial number 3 is the relevant portion, your lordship.
okay, as per the notification dated
27.
3/5/2025.
Yes, your lordship.
Okay, as per the serial number 3.
Yes.
Of the notification dated, the notification number 27 dated 3/5/2025. Okay. Okay. Okay, it will be listed before the same court. Next.
Item number 28.
Yes. Well, application was filed because my bill rejected by the district and Session Court. The case is very I was previously on bail. Filing case number 86. Trial is going on. Just a minute, Okay. Filing page number 18. 18, operative portion of the previous bail order. I was I was granted bail on 4 February 2020.
Yes.
4 February 2020. Operative person of granting bail is page number 18. Kindly see condition number 4. Condition number 4. During the course of investigation. Here is a condition that during the course of investigation, I did not leave the jurisdiction of Assam without intimation to the IO investigating officer of the case. That is one of the conditions. Accordingly, Lordship, I was released on bail. And then I was accordingly on this bail condition. I was
Okay.
Yes. Then what had happened? Why I have been taken here is that page number 19, annexure number 5. Page number 19. This 26 March 2025.
Yes.
Investigation was completed at the point of time, and I have been searched again. So during the course of trial, what has been submitted on 26 March 2025. On that appointed day, during the course of trial, I could not appear because there was an accident. I got received injury. That is why on that particular day I could not appear.
So your counsel was there? The step taken for making application?
Under what circumstances I could not appear before the court on that at that particular day. I wanted to specify this another court. Kindly see this representative counsel has stayed. My defense counsel has stayed.
Which one?
Page number 19, annexure number
Yes,
5.
yes.
This para 3. He submitted the accused person is not cooperating with me and has not appeared before the court without any information. Issue non-available warrant of arrest against the accused person and notice to the bailor. Accordingly, on that particular day, bailor was issued summon and against me non-bailable warrant of arrest was issued. And on that particular day, case was fixed on after so many months. Matter has been fixed on June. From March, and matter jumped to June. On 26 June 2025, matter was fixed for further trial. 26 June, 23rd June. And what had happened on 23rd June? It is a page number 20, annexure number 5. Kindly see. Page number 20, annexure number 6. Yes, annexure number page number 20. Kindly see. Again, I am reading the paragraph.
That's right.
Yes. I have heard the accused person who stated he could not appear before the court as he was at Kerala for some more. It's observed that from the record, the case was granting the bail to the accused person by order number 7, DA number 7. The condition of report upon the accused person, including that accused shall not leave the state of Assam and Arunachal without prior information. It is observed that accused person while going to Kerala was not taken any permission for giving information regarding his leaving state of Assam and Arunachal Pradesh. Even the accused person remained absent during the trial of the case, causing unnecessary delay in the trial. As such, the bail granted to the accused person cancelled on violation of the bail condition. That is the condition on which bail has been cancelled. And on that particular date, again on 23rd June, my bailor has filed a page number 21 against page number 21. Seeing the miscellaneous application number 116 2025 under section 459 of PNSS. Yes, my bailor has filed an application saying before the trial court saying that he is not going to extend as my surety my ballot anymore, saying that he has so many nonsense. Some inability he has shown the court. Accordingly, he has been, my ballot has been discharged from being a ballot. So I was again put to judicial custody on that day, whereas I was again taken back to the judicial custody. So I was praying the court that I am ready to party suitable ballot. If my ballot is not ready to stand for me as ballot. But again, I was taken back to, from that day, I was taken back to judicial custody. And after taking back to judicial custody on page number 21, election number 7, this is my application. Page number 22, election number 7. This is my bail application. Okay. Before the special judge NDPS UPR, saying that I'm ready to submit this suitable ballot and I'm ready to cooperate with the trial. Since I have been taken back in the judicial custody and it is about 3 months. So I have pleaded before the court that I should be given not given the custodial trial. Since I am having married person, I'm a married person having children, and my family is facing hardship. Since I am the only earning member of the family. So, I being a labor man, labor person, labor class. So, my bail application is rejected. Whereas I am ready to furnish any suitable ballot during the course of trial. This trial is yet to be completed. It will take more time also. So, under these circumstances, I am praying honorable court for release me on bail during the course of trial. So, I am ready to furnish suitable ballot. Yes. And whatever condition may be. I'm ready. Yes, Ms. Jenny.
Yes, Your Lordship, if I may, I have gone through the record, Your Lordship.
Okay.
Your Lordship will see that an FIR was lodged against him under section 21B NDPS, Your Lordship. Subsequently, he was arrested and as shown by my learned counsel, Your Lordship, he was granted bail on 4/2/2020, Your Lordship. And one of the condition was that he shall not leave the state of Assam and Arunachal without prior intimation to the IO, Your Lordship. Subsequently, what has happened was, Your Lordship, the trial was committed to, if Your Lordship will see the order in the record, Your Lordship. Trial was committed to the learned special judge and the case was taken up first by the sessions judge on, a special judge on 11/10/2022, Your Lordship.
Okay.
Thereafter, Your Lordship, he did not, notices were sent, Your Lordship. The services upon him was awaited on many occasions and finally.
Now he has been inside the custody for 3 months. Earlier, for how many days you were? It was not, it was just after bail. Kindly see the date. No, in first arrest. First arrest. So after how many days you were released? About date of arrest and closed. I was arrest memo come, it was the 23rd January 2020 and I was released on in the first train in the February, 4th February. Not even 1 month. It's about a month. It was a month, more than a month.
I'll just
NDPS.
I'll just convince Your Lordship because
Not even month.
once the court has cancelled someone's bail, Your Lordship.
That's difficult.
Yes,
I know.
it's very difficult, and I'll just show that how the trial was impacted because of his absence, Your Lordship. And why was the impugn order was passed, Your Lordship? As I have already pointed out, on 14/6/2024, the trial started, and PW1 and PW2 was examined, Your Lordship. Thereafter, he did not appear on all the occasions, Your Lordship.
Okay.
Till the last date of
Hmm.
when his bail was cancelled, Your Lordship. Now, on all these occasions, if I may take, Your Lordship,
Any material whether he is likely to be
Yes.
convicted?
yes, Your Lordship, because since his deposition has not been taken up, your lordship, and all the witnesses, five of the witnesses examination has been, deposition has been taken, your lordship.
Okay, how
There
many?
is only one on 6, your lordship. Only one of the witnesses, Caesar witnesses, deposition is to be taken, your lordship, and the
Okay.
date is fixed on November 2025, your lordship. 6th,
November 25,
6th of November 2025.
6th of November.
Yes, this coming November, your lordship. Your
Mr.
lord-
Tapa,
your lord-
otherwise ready, but then I think that means the last one.
Yes,
That is
last, yes, your lord. All the experts, evidence has also been taken, your lordship. They have also,
Have you
deposition
gone
has
through-
been taken.
Have you gone through the?
Yes, your lordship.
There is a material.
There are materials, your lordship. Even since he'll be cross-examined, he'll be put up a question under 313, your lordship. In
Yeah.
his 161 also, he has admitted to the fact that he was also consumer as well as he was
Okay.
in the state of Assam and Arunachal Pradesh, he was also selling the
Contraband.
contraband
Hmm.
substances, your lordship. Your lordship will also notice that
Which PW has implicated him?
your lordship, all these, because all of them
Now-
were
Now,
police.
now, because at the end of the trial, it's
Yes.
very difficult. And if there is especially if there is any,
In fact, your lordship will see the court has taken the step for cancelling of his bail because he was not even cooperating with his own counsel, your lordship.
that is the
That
reason.
is how it came to the court's notice, your
Mhm.
lordship. And on all the occasions, your lordship, he was absent without step, and the prosecution witnesses were examined. And thereafter, when the notice was issued to him, NBW notice was issued to the accused as well as to the bailer, that's when he appeared before the court, your lordship.
What is the punishment for if he is convicted? What is the maximum punishment or minimum punishment here?
7 years, your lordship.
7 years is the minimum.
Your lordship, I'll just go to him.
21B
Yes,
would be 7 years.
yes.
7 years, I mean. Yes. So, Mr. Tapak, it will be a little difficult at the end of the
Lordship, I
trial. And then if there is a material, especially,
may submit, Lordship.
and then
Kindly see
scientific,
And the unfortunate fact is that the trial was investigation as well as the trial was pending only due to his absence, your lordship. It started from the year when it was committed from 2020 till 2025, your lordship. That's when his bail was cancelled. your lordship.
could be seen, that is why.
Lordship, kindly say, what I have submitted, Lordship. I'm the sole earning member of the family, Lord. I have a children and a married person. I am ready to furnish suitable bail, Lord.
See,
My-
you have failed, miserably failed once, and then you.
My colleague has submitted, Lord. Next date of trial for examination of seizure witness on 11th of November 2025. And hereafter, also, 313 examination is there. Which means that will be, this is today is September. It is November, then after 2026, 313, it might be probable date 2026. And thereafter also, what I have to defend my stay while outside the
No, you have been defending while inside.
outside.
Only one seizure witness remained. And then you see the
313 is also clear.
the scientific officer also has clearly stated there is a
313
morphine known as heroin, morphine, brown sugar, etc. So
And
these,
Also, your lordship,
probably 11th of November, the either witness may come or may not come. Time will, there will be time, it is a time taking process, it twice. And thereafter,
see,
even
there
after-
is a, there is a, see, Supreme Court's judgment that at the end of the, when the trial is at the end of the,
kindly,
means in the last stage,
kindly,
and then if there is, especially if there is a material,
kindly see, that is
there is a
another.
restriction.
What is the ground for cancellation law? Ground for cancellation, that is to be seen now here. What is on record? Ground for cancellation. I am again.
No, no, I have
emphasizing
seen he remain absent because of him.
Kerala, kindly say, the ground,
No, you did not make any application while you remain absent.
Yes.
Your your advocate or a counsel, defense counsel did not make any application. But when he was caught, when he was arrested in execution of the warrant, then only he started this, that he has been to Kerala.
Number one, I'm a labor class person, uneducated person. Okay.
Uneducated, labor class,
This is the key.
such business, Kerala.
And when the sole earning member of the person, the family, created inside the jail for such a long time, what will be the situation of the family though? That has to be taken into consideration also. And also on merit, bail has to be seen.
Now,
Under what
about
circumstance?
his business? What about his business, which will spread or which spread?
Definitely, I will place my defense with I myself be also. That is here. And from prosecution side as well, here is this time, there is a time taking course. Time will not so kindly see, this is the ground for cancellation is okay. Only on the first instance, at first, here is the report from this advocate saying that my client is not cooperating. Accordingly,
Heard Mr. T. Tapak, Learning Counsel for the petitioner. I've also heard Ms. T. Gini, additional PP for the state respondent. Tapak. Who is the applicant?
applicant is
Wife.
The petitioner, who is the wife of the accused, has filed this application under section 483 of the BNSS 2023, praying for granting bail to the accused, who has been detained in custody since 23/6/2025. Stop. The accused was arrested on when? First arrested?
first arrested on February 2020. The February particular date is kindly seen. 4th February.
Hmm.
Date of. the date of
23/1/2020,
23/1/2022 in connection with
2020, Your Lordship.
the 2020 in connection with
The date of arrest is 23rd.
in connection with Bandadwar PS case number 1. What is this? NDPS case number 3122 in Bandadwar PS case.
Date of arrest is 23rd January 2020.
20?
23rd.
I have recorded, but don't repeat. Yeah. In connection with Bandadwar PS case number
1, Your Lordship.
01/2020 under section 21B of NDPS Act. No. In NDPS case number 31/2022 arising out of Bandadwar PS case number 01/2020 under section 21B of NDPS Act. He was granted bail and released on 4/2/2020 with certain conditions by the with certain conditions, including the condition that he shall not leave the state of Assam and Arunachal Pradesh without prior intimation to the IO. The record reveals that the accused remain absent for trial of the case. And accordingly, his bail was cancelled and issued non-bailable warrant of arrest against him on 26/3/2025.
Your Lordship, if I may, Your Lordship.
Hmm?
Your Lordship, on 26/3/2025, his appearance was shot for and therefore NBW was issued, Your Lordship. His
Okay.
bail was subsequently
Not
cancelled.
cancelled.
Not cancelled on that
Initially
day,
not
okay,
cancelled. It was
okay,
just
okay, just a
summoned.
minute. Then,
Accordingly, he
okay,
complied.
okay, as he remain absent, non-bailable remain absent for trial. A non-bailable warrant of arrest was issued against him and notice to his bail
Case number 9.
on 26/3/2025. Okay. By which order is?
23/6/25, his bail was
Okay.
cancelled.
Okay.
Next, okay.
So, in execution of the non-bailable warrant of arrest, the accused was arrested. When he was arrested?
Not in execution note. It is not in execution of bail application, but he was appearing on summon, being summoned. The accused appeared before the court
No.
on
He
being
was-
summoned. Kindly see page number 9.
After non-bailable warrant of arrest, he was again summoned.
No, kindly see page number 19. Read the contents doc. Page number, annexure 5, page number 19. Kindly see the para number 3 and 4. Doc. Para number 4 say, speaks for 23rd June 2004 appearance of the accused and for product of the case. Accordingly, Lordship,
Say, non-bailable warrant of arrest was issued and then production of the accused fixed on 23/6/2025. What are you submitting? Where is someone? Don't confuse. Don't try to confuse. On 23/6/2025, on his appearance. His bail, the bail granted to the accused on, that was 4. When? 4/2/2020 was cancelled on violation of, on a ground of violation of bail condition by the accused. And also and also allowed the miscellaneous application filed by the bailor for his discharge as bailor, being bailorship. The accused accordingly was the accused accordingly was taken into custody. So, and since then, the accused has been under custody for about how many days you said?
it's, for the next, tomorrow it's 90 days.
No, for about 90 days. For about 90 days. Stop. Thereafter, the bail application moved by the accused on was rejected on 4/8/2025. Stop. By filing this application, bail application, the petitioner prays for release of the accused on bail on the ground that he is the only earning members and he is ready to furnish ready and willing to furnish adequate bail bond to secure his attendance. And he is the only earning member with wife and minor children. And that, and he is ready and willing to furnish adequate bail bond and for securing his attendance. It is submitted that the learned additional PP submits that the trial is at the last stage. Only one seizure witnesses is to be examined, and there is a material, incriminating material evidence against the accused for commission of the alleged offense. Therefore, she opposes granting of bail to the accused at this stage. Start. Mr. Tapaglani counsel for the petitioner submits that he is innocent of the charge and need to defend his case from outside by producing defense witnesses, and the trial is not likely to conclude. When the trial is likely to take some a longer time, therefore pray for release of the accused. Stop. Considering the entirety of the matter and considering that the accused was once granted bail and his bail was rejected only on non-appearance for trial once when he was out of station at Kerala. This court is of the opinion that the prayer of the petitioner can be considered to facilitate him to defend his case. So accordingly, this bail, accordingly, the bail application is allowed. So the accused is directed to be released on bail on execution of a bail bond of rupees. What is the fine, maximum fine?
Your Lordship, I have earlier mentioned wrong, Your Lordship. It's up to 10 years and 1 lakh of fine.
1 lakh, no, okay. 1 lakh, with two surety of like amount to the satisfaction of the trial court, one of which shall be the resident of Arunachal Pradesh, with the further condition that the accused shall appear for trial of the case on each date to be fixed by the trial court, and that
Your Lordship, I'll just a small submission, Your Lordship. Lordship is, since granting bail, Your Lordship,
Yes.
I'll just like to put up my submission, Your Lordship. So, Your Lordship, once the bail of a person, if there is a violation has been cancelled, Your Lordship.
No,
That
the
cancellation-
I've seen. Violation, it was, because we had a reason that.
No, the subsequent bail application that they have filed before the trial court, Your Lordship. The other ground that was given before this, when he was arrested, when he was before the court custody, Your Lordship, he has made a submission that he was in Kerala for some work, Your Lordship. Subsequently, he had filed a bail application before the same court, Your Lordship, wherein the ground given was that he had met with an accident and there was no proof thereof, Your Lordship. Now the court, while also rejecting that, first it was cancelled and the subsequent bail also was rejected, taking into consideration that before the court, he has mentioned that he was in Kerala for some work.
Okay.
Subsequently, in the bail application, he gave a reason that he had met with an accident, and that also without any documents whatsoever, Your Lordship.
Okay.
And therefore, even the second bail application
That
was
is
also
in the
not.
bail order.
It's in page number 22, Your Lordship.
Mr. Thapa, then it will be difficult if you suppress and if you try to.
Page, I'll just,
Page
page number 22, Your Lordship.
22.
I'll just rely upon only, I'll just,
What has happened?
Okay, where?
rely upon paragraph 6 and 7, Your Lordship.
Went to Kerala before this court, went to Kerala for some work, could not appear
Yes.
before the court on the date of hearing. According to the bail granted to the cancel for violation of, okay. Then where?
6 and 7.
Okay, made in the accident.
6 and 7, Your Lordship. I have carefully perused the record of the case and seen that earlier accused person was allowed to
What?
go.
Bail application is also there. Because he.
No, he has
clearly-
not even annexed that application also, Your Lordship. Your Lordship will see.
No, in the record, have you seen?
No, it's not there, Your Lordship.
Not on the.
It's not there. My other submission is, Your Lordship. I'll just
Let him-
make my submission, Your Lordship.
Now it will be difficult.
it-
Once you try to suppress the material, once you try to mislead the court, that becomes extremely difficult. Not even as smallest of the small, 1% also misleading will be difficult.
Now,
May I submit notice? Either I submit or.
Okay, you take.
May I clarify the matter? First of all, what has happened actually? There is a confusion in the court. Kindly see this, as per this, at the time of that explanation given by the,
During
when
the
he
time
was
of-
rearrested there and produced before the court.
Just a
If
minute,
accused
just
person is
a minute, just a minute. The bail application is not here. Not on record.
not on
Any-
record, Your Lordship.
accused person,
Do you have the bail application with you?
no, I do not.
Don't have.
It must be part of a report also. Because there was the IA was there, verification was there. Lordship.
Now then,
My submission-
in that case,
at
in
this
that
point
case, we may require that records. Okay, so this is a serious allegation. Court will never tolerate misleading. Then, just a minute. Heard Mr. Tapaka, Learning Council for the petition, also heard Ms. Jenny. Okay, Ms. Jenny. Some is that earlier when earlier the applicant, sorry, the accused, while justifying his absence in the court, stated his absence in the before the for the trial, stated before the court that he went to Kerala for some work and could not appear before the court on the date of hearing, which has been reflected in the bail application.
May I clarify also?
Just a minute.
That is not a
Just a
fact.
minute.
May I clarify?
However, just a minute. However, in his bail application, he has stated the ground that he met with an that during the time of March 2025, he met with an accident and was admitted in hospital. And thus the petitioner has made a contradictory plea, clearly showing that the accused has not approached the court with clean hand. In view of the above, she prays for some more time to produce the record of the bail application filed by the accused, filed for release of the accused before the trial court.
Your
The
Lordship,
prayer is allowed.
Your Lordship, since I won't be able to produce, Your Lordship, may kindly direct the registry for an updated
Okay.
of the TCR along with all the bail applications submitted before that court.
The in view, okay, the registry is directed to requisition the record of trial court record, more particularly the bail application
Yes.
filed by the file for the release of the accused. Somebody has filed. Okay, which bail application is this?
File for the accused.
Okay, when this
It's,
bail application,
it's BA 363 of 2025, Your Lordship.
more particularly the BA
363 of 2025.
BA number 363 stroke 2025. Scan copy, scan copy of it. Okay. List this matter when?
Your Lordship, today,
Next week will be holiday,
yes, Your Lordship.
then Friday.
On Friday, if possible, Your Lordship, if the record comes, Your Lordship.
Okay,
Otherwise,
Friday. Okay, Friday. Okay. Yes.
Your Lordship, item number, I deeply apologize,
Any
Your Lordship. I'll just, item number,
and probably there is a paucity of time. Yes.
Your Lordship,
item?
item number 27, Your Lordship.
27?
That has already been, the item has already been gone, Your Lordship.
Yes.
Item number 27, Your Lordship, I'll just clarify, Your Lordship, we haven't noticed serial number 2 of notification 27, Your Lordship. Serial number 2 says that if any bail application arises of the same FIR, because in that case, Your Lordship, particularly case, the same accused has not approached before this court. That is another person, doctor, Your Lordship.
But in the same case, probably it covered.
Yes, I'll just come to, I'll read the serial number to Your Lordship,
Mhm.
because there was certain modification after notification number 26, Your Lordship. If I may read, Your Lordship.
Yeah.
All bail application arising out of the same FIR which are filed in the Guwahati High Court are to be listed before the same honorable bench who has previously disposed of bail application pertaining to the same FIR only if the said honorable judge is taking up criminal matters irrespective of the fact that the bench may or may not be taking up matters as per roster. However, in the event the honorable judge is sitting in a division bench or is not holding the criminal roster or is stationed in a different state under the jurisdiction of the Guwahati High Court, the instant direction would not be applicable and as such the matter may be listed as per the roster. If this is to be considered, Your Lordship, then even this bench can take up that matter, Your Lordship. Because serial number 3 more particularly speaks of the subsequent bail application on rejection or on dismissal, disposal, Your Lordship. However, in this case, to item number 27, Your Lordship, this person has for the first time this person has for the first time come up before this court. I may just pray that this matter be listed day after tomorrow, at least that particular 27.
Okay, then cancel that one. Okay. And then this application, the petitioner has to be informed.
This complainant, Your Lordship. Petitioner was absent today, Your Lordship.
Not petitioner, complainant.
Yes.
Then but not appears on behalf of the petitioner, Item 27. Whereas Ms. Jenny Leonard, additional PP, and Mr. Whose name was?
It seems his name is, Your Lordship, will M.K. Agarwal, Your Lordship.
Agarwal, appearing on behalf of the informant are present. Is grateful by Ms. Jenny Leonard, additional PP, let this matter be listed at June.
On 24th, on 24th, Your Lordship.
24th.
Yes, deeply obliged.
Will it examine? Okay, yes.
Item number 29.
Maybe.
Yes, my lord.
Oh. Yeah.
My lord, the incident related to rowing mob lynching, my lord, and serious breach, my lord.
Okay.
My lord,
I think he is a name accused.
yes, my lord. In the FIR, he is the name accused, and in the statement, my lord, statement of the accused person who's been arrested, my lord. They have also categorically stated the name of the present accused person, that they were present in the police station, and he was the one. He, along with my lord, one of the co-accused person, my lord, Milo Lingi, my lord, whose bail application
Okay.
was
Okay.
yes, my lord, whose bail application was earlier rejected by my lord only.
Mhm.
And they are the two persons who, under whose instigation, my lord, the mob,
Yes, yes.
yes, the mob barged into the police station and they broke the lockup and drag out the victim. This is victim from the lockup and assaulted near the police station. And somehow this police could disperse the mob and taken the deceased victim deceased to the district hospital rowing. Again, there, my lord, this accused person, my lord, they followed the
Yes, yes, I remember.
yes, my lord,
Yes, what
and
happened?
they are again taken.
Police for his safety again took him to police station.
Yes, my lord.
Hmm.
He was
Like,
yes, my lord. This person was again taken out, dragged out from the OT from the district hospital by the mob, my lord. So, my lord, categorically, my lord, if see, my lord, I have flag mark, my lord, the statement of the accused person, my lord,
Mhm.
in the CD, my lord.
accused person is the present accused.
No, my lord,
No,
the
some
accused
other-
person was arrested, my lord.
Okay. Okay, arrested. accused person.
Yes, my lord, this one, pink flag mark, my lord, pink color flag mark, my lord, pink color, second last, my lord, second last.
What is name of the present accused?
Present accused person is Iho Lingi, my lord. There I have marked the name of the accused person with pencil, my lord.
Yes.
Yes, my lord.
Igo Lingi.
Yes,
Iho.
Iho Lingi, my lord.
Yes.
Yes, if my lord turn to the next page also.
Went to where the mob. Were present.
Yes, my lord.
All to SP. And
one of the
arguing with
accused.
SP.
Yes, my lord. He was arguing with the SP, my lord.
SP must have also been examined, I think.
Yes, my lord. SP must have been, my lord.
Okay. Okay, he is the one who demanded
Yes, my lord.
the accused to be handed over to them. Hmm. And then
All arrested accused person has stated the name of the present accused person that
Yes.
he was the one.
all have taken his name.
Yes, my lord.
Yes. Yes, anything?
Yes, I will. My lord will see, my lord. There is two FIR, my lord. Two FIR, my lord. Now, past FIR, my lord, in with allegation that, my lord, deceased was dragged out from the police station, my lord, he was beaten and he became unconscious, my lord. That is the last part of the FIR, my lord, of the past FIR, my lord, if my lord see, my lord. Thereafter, second FIR report about the incident in the hospital, my lord. Now, in past, according to the PP, my lord, he's saying, I was the part of the incident in the police station, my lord. Now, if my lord see in the FIR, my lord, past FIR, who is report up to the incident of the police, my lord, there is, my name is not there, my lord. I'm not the
Any
name.
difference between the first FIR and second FIR? This is in first FIR or second FIR?
This is the second FIR, my lord. Second FIR.
Second FIR.
First FIR was lodged when the
There was no name.
no name.
Okay.
name.
Here,
The only this Milo Lingi name is
yes,
mentioned
yes,
there.
only the advocate.
After verifying the my lord CCTV footage, Then only police would
Second
identify.
FIR.
Yes, name has been revealed.
Because
As of now, my lord,
apparent.
yes, my lord. As of now,
Cannot be a submission, my lord.
as of now, my lord,
His submission would be based on CCTV on the statement of the co-accused, my lord. That cannot, the police, my lord, cannot be allowed to make a contradictory statement and put a different thing in the record, my lord. My lord will see, my lord, there is a two FIR, my lord.
Yes, yes.
Past FIR, my lord, allegation, my lord, I am allowed to read the past FIR. Past
I
FIR,
have seen.
past FIR, my
Past FIR
lord.
also seen. And second FIR also.
Second. Now, past FIR in with, my lord will kindly have a look, page note 23, my lord. Past FIR in N with, my lord. At around 11:30, all of a sudden, a group of mob, my lord, consisting of 8,500 and 600 people, led by advocates such and such of the rowing into the police station, rowing. Despite resistance, the mob overpowered the police personnel in duty and vandalized the police station, locked up and took out such and such custody and brutally attacked the alleged accused Mr. Such and such in front of PS rowing. As a result, Said Karim shall be injured and gone to the unconscious state, my lord. If this is true, my lord, if this CD, my lord, the state is to the hood, my name should be in this, my lord. But my lord, my lord, there is no my name in past FIR, my lord. Subsequently, after the second, thereafter the second FIR report about the incident medical, my lord, there is my name, my lord. Now, therefore, my lord, on the record, my lord, I have tried to explain how where I was in the police station, my lord. On the record, my lord, will see, my lord, there was FIR, my lord. FIR by my mother and sister, my lord, and that was forwarded to the police station by my lord. This is central. One is Sakya, one is central administration, my lord. Now, after less of 3 months, my lord. Also, my lord, that was not acted upon by police station, my lord. Accordingly, on that day, my lord, when I was on police station, my lord, the mob come in, my lord. Yes, before that, my lord, I have some hot argument with those police present in the police station, my lord, because, my lord, my FIR is not registered, my lord. They are not acting upon me, my lord. No, and I have made a categorical statement in my application, my lord. From the police station to hospital, my lord, I was in the van of the police station, police van, my lord, to assist while lifting the victim in assistant, my lord. And that would be a part of.
You were the one who demanded. Your main, your associate has clearly stated, you were the one who demanded for release of the deceased or handing over of the deceased.
No, my lord.
yes, ma'am.
Okay, anyway, so at the moment, I know all these facts, so it will go in the same way.
No, before that, my lord,
Where is the bail order passed earlier? It will
My lord,
go in
pay
the
order
same way.
first. This one.
Do you have the copy?
Yes, ma'am.
I know, I have seen
no, my lord.
earlier.
Before
Because
that-
I have also earlier also heard.
No, yes.
Only the record was to be seen.
Yes, my lord. Before that, my lord, considering the liberty, my lord, which has a pastoral value in the constitution, my lord. I will submit, my lord, give me some 4 or 5 minutes, my lord. I have tried to put some.
See, I have seen the records. I've heard also, earlier also I've heard you.
No, earlier occasion, I was not.
No,
My
no,
lord,
because
my lord.
you pointed out the same thing.
Yes.
No, no,
Two FIR, I
that-
remember.
that is on the
Two
fake.
FIR and then you made a submission.
No, my lord.
What new submission?
That is on the fake, my lord.
Because
I-
that I have seen that you were involved in earlier, because you said that you were, prior to the mob came, you were already there. That is your submission.
Yeah, my lord, that
And
is-
you had an argument because your relative had some
yes,
cases.
that is on the fake, my lord. I'll try to move on to some legal aspect, my lord. Now, my lord,
Okay.
is bail now. Now, if I correctly understand the argument of VP, my lord, he is saying, my lord, at this stage, my lord,
Mhm.
they require my custodial interrogation because there is a serious allegation, my lord.
Mhm.
Now, at this stage, I do concede, my lord, gravity of offense, my lord, gravity of this allegation, my lord, can surely be relevant consideration, my lord. But in addition to that, my lord, we will see, my lord, that accepted, my lord, well jurisprudence, my lord, the golden consideration would be, my lord, whether at this stage, my lord,
there is chance of, my lord, tampering the evidence, my lord. At this stage, my lord, whether, my lord, my lord, would play away from a trial, my lord. My humble submission, my lord. At this stage, my lord, at these two principle, my lord, out of 3, my lord, is in my favor, my lord. The balance, this is already 2 more, my lord. Pass, my lord. There is no effort, my lord, from the IO, my lord, to hold me or arrest me, my lord. If that is so, my lord, for whole this month, my lord, my custodial interrogation is not necessary, my lord. And at this stage, my lord, it not would be possible that I will temper the evidence, my lord. Therefore, my humble submission, my lord, simply on the gravity of offense, my lord, seriousness of the allegation, my lord, my bail application, my lord, cannot be rejected, my lord. So that extent, my lord, I rely on judgment, my lord. Of those.
Then I have only 2 options, one to reject or to grant. If I cannot
Yes.
reject, then I will not be able to take up the matter.
My lord, to that extent, I am relying.
If I have only one option, then it will be difficult for me to take up the matter. If you give me only one option, I thought I have 2 options.
My humble submission, my lord, I did looking into the bail jurisprudence, my lord, this is a quick case.
Yes, I have.
It's an
Yes,
bail, my
but then you see,
because, my lord,
this case is different.
no, my lord, my humble submission, I do consider there is a serious allegation, my lord. Assuming, my lord, his statement in the record in the CD is true, my lord.
Yes.
Then also, my lord, my humble submission, my lord, in the bail jurisprudence, my lord,
Yes.
punishment in the form of lesson, my lord,
Yes.
before forward trial, my lord. Conviction is never approved, my lord. Therefore, at this stage, my lord, there is no chance of tempering the witness, my lord. There is no chance that I will plead. I am ready to cooperate, my lord. Therefore, my lord, only the gravity of offense, my lord, cannot be granted for reaction of my antecedent will, my lord. I rely on judgment by the apex of law. This is, my lord. This is 2020,
What it says?
11 S, my lord. This is in the same section, my lord. I will reading, my lord, para 44, my lord, 4, 4, my lord. 11 para will be 4, 5, and 7, my lord. For learned counsel, applicant has submitted the accused such and such is at least 5 other criminal cases under same police station. He has also brought to our notice the witness statement. Similarly, my lord, the PP is saying, my lord, I have been named by the one witness, my lord.
Not one.
So,
5.
Five of them have
but
taken
here
name.
also in the similar situation, in this case also, he was named by. He also was brought in our notice the witness statement one such and such. This statement was recorded on this part of the statement on which our attention is drawn by the learned accused. That the said victim saw such and such, such and such. Now, 5, my lord. The allegation, my lord, is same. Is where we have considered the respective submission. The peg highlighted by the applicant are that this case involved offense under 302, my lord. This is now similar case for whom I am before you, lordship, my lord. Read with 120B, my lord, similar, my lord. 147, my lord, 148, 149 in the penal code, my lord. In this case, now at para 7, my lord, on considering the submission, the 11 I am relying is, my lord.
Okay, Mr. Albamri, I have heard you.
Plus, second, my lord, also I am relying, my lord. This,
I'm on the fact. I'm on the fact of the case.
No, that's why, my lord, fake, my lord, assuming, my lord, at this stage, my lord, there is a even statement by the co-accused, my lord, assuming, my lord, there is a statement. I'm, the allegation in the FIR is true, my lord. Then also my humble submission, my lord. The 3 principle, my lord, at least 2 principle consideration, my lord. One, my lord, yes, gravity.
This is not a court. What it says. It is the rule of law which should prevail.
Yes, madam.
Rule of law should prevail.
Yes, my lord.
And then no one should take
now
the law in their hand.
In the rule of law,
this we cannot allow in the society. He personally asked me. So
No, my lord, my humble submission, in the line of the rule of law, I am submitting that, my lord, in the, this is bail application, my lord. In the bail application, the consideration would be, my lord.
See, the fact is with me, entire fact
That's why, my lord,
I've
I'm,
gone through. You can see also.
no, my lord.
Okay.
That's why I'm relying, my lord, this
Okay.
220, my lord. Only
Okay,
the gravity, my lord.
I have heard you. That is why.
Allegation. Additional, my lord, one more reliance, my lord.
Oh, Mr. Parme, so people are waiting, other. I've heard you. Do you think that you'll be able to convince against this?
No, my lord, my humble submission, my lord, that, I maybe not, but I humbly believe, my lord, at least for it.
You know now, because I have seen all these, I'm indicating you.
No, my lord, that's why, my lord, that's why I'm saying, my lord, how serious may be the allegation, my lord?
Yes,
That cannot be sole consideration in the bail application, my lord.
right. That is true.
That cannot be, my lord. Therefore, my lord, at this stage, it is not that this incident happened 2 or 3 days back or 2 or 1 week, my lord. This incident, allegation, the incident happened, my lord, 2 months prior, my lord. Now, it has only 2 months passed, my lord. Now, there's, I believe, my lord, there should be some balance, my lord. Yes, there is serious allegation, my lord. But at this stage, after all, my lord, the criminal jurisprudence, my lord, a person can be punished only after proper trial and conviction, my lord. Therefore, my lord, at this state, if I want to cooperate, my lord, if I want to, if there is no chance of tampering the witness, my lord, if,
Now see, the police would not be able to arrest.
if police say, my lord, I am trying to influence the witness, my lord, I will not
That
praise the
police
my bail
police
application.
authority will take care of.
Only the allegation police is saying, my lord, I was the main accused, my lord.
And then if you are successful absconder, or if you are means if you succeed in your own way, then you are very intelligent.
No, my lord,
Then if the police fail on their part, the police department will take care of it. But then for now, for me, I have seen and I know the fact reveals here, it is here, and there is a material which I found that I cannot, or this court is not inclined to extend the benefit of the pre-arrest bail at this moment. Accordingly, the bail stands rejected. Okay?
Oh, madam.
I'll say later on. Huh? And the rest we will not be able to take up today. Any
My lord,
urgent?
item number 37 that may be listed on 24, madam.
Hmm?
Hearing, madam, item number 37.
What?
Item number 37, madam.
What?
Madam, fixed for 24, madam, 24.
64?
24. Fixed on,
37?
yes, madam.
It's great for by. 37, you are for?
I'm for SIT
SIT, Lara Council. The council for the other side is your
with the consent from other side, yes.
Okay. With
Your
the council
Lordship,
of Lara Council. Other side. Please this matter on
24.
October. Yes, you are for?
My lord, 24 this month.
24 of this month.
Yes, my lord.
What is this matter about?
My lord, this is
24.
24.
24, huh? Okay.
Your Lordship, do I have the permission to mention item number 34?
Yes.
Your Lordship, it's a restoration application
Okay,
for
just
the
then, these are in order. What else can I say? We will have another to finish it. I think this order, so we have to pick. Or anything, any urgency, they are in order.
Item number 36, I have just been informed that they will be taking fresh steps.
Okay, item 36.
Yes, Your Honor.
Okay. Okay,
Mr. J. Koyu.
J. Koyulani Council for the petitioner, praise for granting 1 week time to take fresh steps upon respondent number.
Respondent number 2.
Prayer
Your Honor,
allowed.
may I pray for taking service to the jurisdiction police with an excuse right. Granting to the public prosecutor's office.
The prayer is allowed, saved upon the respondent number
2.
2 by through the
Public prosecutor's office.
public prosecutor.
Routing through public
No,
prosecutor's
through
office.
the jurisdictional police station to be routed through the public office of the public prosecutor. Okay, within 1 week. Okay, within 1 week.
Your Lordship, may I mention item number 34, Your Lordship?
Yes, yes.
Your Lordship, I'm requesting for a short date. It is a fresh matter. It is a fresh restoration application that we have filed for recalling of a
Okay, let's
order,
wait for
and
party. You are Miss, you
Ishita
are Miss
Mishra, Your
Livina.
Lordship.
Your Lordship, I am Livina Jini, appearing as a, yes, Your Lordship. I'm appearing as a local counsel
Okay.
for the applicant petitioner.
When do you
on-
want to say?
Sorry, Lordship.
When do you want?
I am the local counsel.
Okay, local council, when do you want this matter to be?
Your
discussed?
Lordship,
Uh,
Your Lordship, if it may be fixed in this week itself, Your Lordship. I am
When?
the main,
This,
Your Lordship, I am the main counsel in the petition, and I have engaged
Okay,
Miss
both are there.
Lavina.
Okay, this week.
Yes, Your Lordship, if it is possible, then it may be listed this
Okay, I
week
pray for
itself.
by Miss Livina J, Planning Council for the applicant, list this matter on 24th. Okay?
24.
Grateful,
Okay, 24th.
grateful, Your
Okay.
Lordship.
Much obliged.
Yes,
May I please, your Lordship?
yes,
Lordship, item number 33.
33.
Lordship, in this matter, I'm for the respondent number 5.
Okay.
This matter is, they have challenged the bail. They have prayed for cancellation of the bail already given. But Lordship, in this case, what happened is charge sheet was filed. Thereafter, a matter was taken up for consideration of charges, and I have been discharged. So far as I'm concerned,
Already discharged.
yes, I have been discharged. There were other accused persons. The charges were framed under lesser charges and they were sent to
Then
the.
it has become infrastructure.
So far as I'm concerned only. Respond 5.
May I, Your Lordship?
Yes,
Your Lordship, in item number 33, I'm the petitioner. Like, I'm for the applicant.
okay.
Your Lordship,
He has been discharged then, nothing
yeah.
remains.
yes, Your
This
Lordship.
is the order, Lordship.
In that case, Your Lordship,
Okay.
there's two cases, Your Lordship, 32 and
Which one?
33.
32 and 33.
They are connected.
32
matters.
remain.
32 will remain, Your Lordship.
Okay, 32, when do you want?
It may be fixed of puja break.
In 32, huh? 32, Mr.
J.
J. Sri, Planning Council for the petitioner is present and respondent is present. Okay. And Mr. Tado, G. Tado, Planning Edition CP is also present. As requested, let this matter be listed after Puja vacation.
Puja break. Your Lordship, since pleadings are already completed, that may be fixed for admission here.
Puja vacation for admission. Okay. Just a minute. Are present. Since the meetings are complete, let this matter be listed for admission after Puja vacation. Okay. 32. 33.
33.
Miss Nikita Langelani Council for the
Respondent 5.
respondent.
5.
Some is that the in the instant case, the accused has already been discharged by the trial court by an order dated 4/7/2025. Therefore, and therefore, this matter has become infrastructure. Mr. J. Siri, Planning Council for the petitioner. Planning Council for the petitioner has considered the same in view of the above. This criminal petition stands dismissed on becoming infrastructure. Okay. In 33, respondent number 2. So it has. This is cancellation is against you also.
Yes,
They are in this case.
yes.
Where is your the order?
Well, I have no order, but my name was not mentioned, not charged sheeted.
No, cancellation is only for one or to you also.
Yes.
Your Lordship, actually, Your Lordship,
Cancellation of how many people?
they were against 4%.
Of 4%.
Yes, Your Lordship.
Now, how many of them from the petitioner have been discharged?
Lordship, charge sheet was filed against 3 persons, including myself.
Okay.
I was discharged. 2 other persons, they were charge sheeted under lesser offense, and the matter was sent to the magistrate court.
Okay.
So far as his client is concerned, they were not even charge sheeted. They were not even charge sheeted.
Okay.
Your Lordship, their name was initially when FIR was lodged. They themselves have surrendered before the police. So therefore, the name was reflected in the FIR.
Okay.
Then
So what happened in the hearing on the question of charge?
Your Lordship, on the
His
same day
name was not there.
on the same day of
Yes.
production, they were given
Okay.
granted bail.
Okay. Then right.
Hard Mr. J 33, hard Mr. J 3, Line Council for the petitioner. Also hard Ms. D.O. Nikita Dangan, Line Council appearing on behalf of the respondent number
5.
5 and Mr. For Mr. This man, huh? Mr. For Modi for the respondent number 2.
Lordship, in fact, in this
What?
case, all of the respondents, respondent number 2, 3, and 4, they were not charge sheeted. Respondent number 5 is myself, who was discharged. 2,
and-
3, and 4, they were not charge sheeted.
Oh.
Then respondent number 5 is myself, who was discharged.
Oh.
So the matter is now in fractures against all of this.
Okay. Ms. Nikita Dangan, Line Council for the respondent number 5, while placing the order dated 4/7/2025, submits that in the instant case, the respondent number 2, 3, and 4 were not even charge sheeted. And the respondent number 5, namely
Kaparai.
Hmm?
Kaparai.
Kaparai, has been discharged by which court?
Sessions Court.
By the session court. So, and in view of the above, this matter has become, what about the respondent number 1?
One is the state.
1 is? Okay,
State.
okay. And then those were present of the recorded. And in view of the above, this submits that the matter has become infractor. So, okay. Infractor, okay. The order dated 4/7/2025 is taken on record and marked as document X for identification. So, in view of the above, I perused the order and I have perused the order and it is their name has not been reflected in the order itself.
Yes, because they're not
Not
charge
even
sheeted.
Okay, okay. The order doesn't reflect the name of respondent number 2, 3, and 4, as they were not charge sheeted, and the respondent number 5, Kaparai, has been discharged as no. Where his name has been mentioned here in the which paragraph?
Lordship, second last page, para 15, the bottom of para 15.
Okay. Kaparai, okay. As no offense was made out against him. So, in view of the above, this criminal petition, this criminal misdemeanor application stands dismissed on becoming infractor. Okay.
May I, Lordship?
Lordship, item number 30, 31, it is same case, connected case. Lordship, this may be, pleading is completed, this may be listed for the hearing.
Mr. You are Mr. You are Mr.
G. Kata, Lordship.
G. Kata, Line Council for the petitioner is present. And who is for the opposite party? We are,
I'm appearing on behalf of Deepang.
okay, and also have Mr.
O Pangam.
O Pangam, Line Council appearing on behalf of Mr. Deepang, Line Council for the respondent. So, it is submitted that the pleadings is complete and is now ready for, completed. Since the parties are duly represented and record also received.
Your Honor, record,
The pleadings are complete, let this matter be listed for
No record.
admission after 3 weeks. Okay. And what else?
there is no record, Your Honor.
No record. No?
Yes.
I have not recorded. Yes. So what else?
Lordship,
It's my overhead, Lordship.
Hmm?
Only, Lordship, this 30-31 is connected case. 30-31 is connected case.
Yes, 30, 31 in both.
Say,
It is which only? Yes, 30 and 31, this one. Okay, yes.
Lordship, in the hearing matter, Lordship, item number 38, Lordship.
38.
Yes, Lordship. Here, Lordship, what happened, Lordship? The conviction period is already over, Lordship. The conviction, Lordship, for 3 years, Lordship.
Okay.
Date of the conviction was 12th day of September 22.
So now person is still under the
Lordship,
custody.
that I have to, Lordship, take the instruction, Lordship, whether they will continue with the appeal or not, Lordship. That amicus this
Yes.
will answer, Lordship. No.
So, Mr. O being a planet amicus is present. Inti Jaran Lanet Legal, sorry, Miss El Hage Lanet additional PT and Inti Jaran Lanet Legal Aid councils are present.
Time for state, Lordship, for one, respondent number 1.
Okay. The first state is first for the state, additional TP for the state and Inti Jaran Lanet Legal Aid council for the
Respondent number 2, victim.
respondent and victim are also present. So, what is your submission?
Your Honor,
To be listed, huh?
Your Lordship, first I take instruction from the jail authority.
Okay, the
Whether
council
he is
for the parties
released or not.
wanted some time to obtain instruction in the matter and prays for some time. Prayer allowed. Please this matter again on Friday. If it is infrastructure, it has become infrastructure, no point. Okay, Friday, okay. Finish.
Only one letter left.
Which one?
35.
35, okay. 35. None appears on behalf of the party on call. Please this matter after the entering puja vacation.